Hello, welcome to Beginner Legal English. This is the first class in Module 1, where we learn how to introduce ourselves and others in a professional way. Today, we will practice words for job titles and departments. We will also learn the verb to be and how to use subject pronouns like I, you, he, she, we, and they. So here's what we will learn today: how to say your name and job title clearly, how to introduce other people. For example, this is my manager, Mr. Lopez. We will practice subject pronouns like I, you, he, she, we, and they, and the verb to be like I am, you are, she is, he is, we are, and they are. Finally, we will learn words for different departments and industries, and all of this will help you make good first impressions in a legal office. Let's imagine it's your first day at a law office. You walk in and someone says, "Let me introduce you to the team." First, you meet Maria. She smiles and says, "Hi, I'm Maria. I am a lawyer. I help clients and write legal documents." Next, you see John. He is busy with some files. He says, "Nice to meet you. I am a paralegal. I help the lawyer prepare cases." Finally, you meet Anna. She is fixing a computer. She says, "Hello, I work in IT. I help with computers and emails." This is how people talk in a real law office. So try repeating after me. This is Maria. She is a lawyer. This is John. He is a paralegal. This is Anna. She works in IT. A lawyer is a person who helps people with the law. That could mean giving legal advice, writing contracts, or going to court for a client. For example, Maria is a lawyer. She helps clients with legal problems. Let's imagine Maria. Her client has a problem with a contract. The company did not pay. So Maria reads the documents, explains the client's rights, and she writes a formal letter to solve the problem. This is what lawyers do every day. They help people understand and use the law. A paralegal is a person who helps lawyers with their work. They do not give legal advice, but they do a lot of important tasks, like preparing legal documents, organizing case files, and doing legal research. For example, John is a paralegal. He prepares documents for lawyers. Let's say John works at a busy law firm. A lawyer is going to court tomorrow, and John spends the afternoon getting everything ready, reviewing contracts, printing evidence, organizing the case folder. He doesn't go to court, but without him, the lawyer would not be ready. That's the role of a paralegal, essential support behind every lawyer. A secretary is a person who answers phones and helps with office work, like organizing schedules, typing letters, and greeting people at the front desk. For example, Anna is a secretary. She answers phone calls. Now, imagine this. A client calls with a question about their case. Anna picks up the phone, finds the right information, and helps connect them to the right lawyer. She's not a lawyer herself, but she keeps everything running smoothly in the law office. The IT department is the team that helps with computers and technology. For example, Anna works in the IT department. She fixes computers. Now, let's say the internet goes down in the law firm, or the printer stops working right before court. Who do you call? The IT department. They fix the problems so everyone can keep working. Repeat. IT department. The legal department is the group in a company that handles legal work. They check contracts, give legal advice, and make sure the company follows the law. For example, Maria works in the legal department. She gives legal advice. Imagine a company wants to make a deal. Before they sign anything, the legal department checks the contract. They protect the company. That's their job. Legal department. A law firm is a business, but instead of selling products, it offers legal help. For example, they work at a law firm. It helps people with legal problems. Picture this. You have a legal question, maybe about a contract or a dispute. You go to a law firm because there are lawyers, paralegals, and secretaries all working as a team to help clients. Repeat. Law firm. Let's play a word challenge. I'm going to tell you a short story. Listen carefully and guess the word from the word bank. Here we go. Maria is a lawyer. She has a big case this week. She needs help writing a legal letter and finding information for the court. She asks John to help. John works in the same office. He is not a lawyer, but he works closely with lawyers every day. He writes documents and helps prepare for meetings with clients. What's John's job? The answer is paralegal, a person who helps lawyers with their work. A paralegal helps lawyers by preparing documents and doing research. Remember that. Great. Let's do another one. Now, let's hear about Maria. Maria talks to clients about legal problems. She helps them understand their rights and what the law says. She also goes to court and writes legal letters. What is Maria's job? It's a lawyer. A lawyer is a person who helps people with the law and gives legal advice. Let's talk about Anna now. She works at the front desk. She answers phone calls, helps people who come into the office, and writes emails. She also organizes meetings for the lawyers. What is Anna's job? Secretary. A secretary helps with phones, emails, and office work. One day, the printer stops working. The internet is also slow. Maria calls Carlos, who works with computers. He comes to the office and fixes the problem. He also helps with email accounts and new software. What department does Carlos work in? The IT department. This is the department that fixes computers and helps with technology. Let's go back to Maria and John. They both work in the same office. Maria is a lawyer and John is a paralegal. They help clients and work on legal cases together. Their office is a company where lawyers and legal workers help clients with the law. What is the name for this type of office? Law firm. Great job. Now, let's learn about subject pronouns. Subject pronouns are words we use to talk about people. Look at the words I, you, he, she, it, we, and they. We use them to say who is doing something. For example, I am a lawyer. You are a paralegal. He is the manager. She works in IT. We are the legal team. They are clients. Come with me. It's Monday morning at the office. I am Ted. I start the day early. Coffee, emails, and contracts. John is here too. He is a paralegal, always ready with the paperwork. Carla is across the hall. She is our IT expert. She is fixing the printer again. Maria and Luis are in the meeting room. They are lawyers. They help our new clients. The clients? They are waiting with documents in hand, nervous but ready. And you are visiting us today. You are learning how this office works. Welcome to our team. Now, my favorite part, phrases and idioms. Let's start with this one. Call someone back. It means you phone a person again, maybe because you missed their call or you want to continue the conversation later. For example, I will call the client back after the meeting. Now, imagine this. It's 9 a.m. A client calls Maria, the lawyer, but she is in a meeting. Her phone rings. She sees the name, but she cannot answer. Later, at 10:30, Maria finishes the meeting. She picks her phone and says, I need to call the client back now. This is, of course, the right thing to do in a law office. So say it together with me. Call someone back. Next is on hold. If someone says you are on hold, it means you are waiting on the phone. You cannot speak yet, but someone will talk to you soon. For example, please wait on hold. The lawyer will speak to you soon. Let's picture it. A client calls the law office. Anna, the secretary, answers and says, Good morning. Maria is busy right now. Can you wait on hold? And the client says yes. Anna puts the call on hold. Soft music plays. And a few minutes later, the lawyer joins the call. This is normal in professional phone calls. Say it with me one time. On hold. Now, let's learn another one. Hang up. To hang up means to end the phone call. When the conversation is finished, you press the red button or you say goodbye. For example, she hung up the phone after the call. Here's a story. John talks to a client. They discuss a contract. At the end, John says, Thank you. I will send the file today. The client says, Thank you. Goodbye. Then click. They hang up. The phone call is finished. Let's do another one. Speak clearly. This means talk in a way that's easy to understand. Not too fast, not too soft. For example, please speak clearly during the call. Now imagine this. A lawyer calls a client. She talks very fast, too fast. The client says, Sorry, I don't understand. So the lawyer tries again. She says slowly, You will receive the contract today. Now the client understands. Why? Because she spoke clearly. In legal work, this is very important, to speak clearly. Now, let's learn take a message. This means write down information for someone who is not available. For example, can you take a message for the lawyer? Here's a story. The lawyer is in court. She cannot answer her phone. A client calls. Anna, the receptionist, answers. The client says, "Can I speak to the lawyer?" Anna replies, "She is not here right now. Can I take a message?" The client says, "Yes. Tell her I will send the documents today." Anna writes the message down, and this is how we help clients in a professional way. We take a message. Last phrase for today, get back to someone. It means contact the person again later, usually with information or answers. For example, I will get back to you after I check the files. Imagine this. A client asks, "Is the contract ready?" Maria checks the files, but she's not sure. So she says, "Let me check, and I will get back to you this afternoon." This means I will call you or email you later with the answer. It's polite, it's clear, it's professional. Get back to someone. Let's end with a short story, a normal day at a law firm. Maria is a lawyer. She talks to clients and gives legal advice. Anna is the secretary. She answers the phone. John is the paralegal. He writes documents for Maria. And Carla works in the IT department. She fixes computer problems. It's Monday morning. The phone rings. Anna picks up. "Good morning." "Maria is not here. Can I take a message?" The client says, "Yes. Please tell her I will send the documents today." Anna writes the message. At 10 o'clock, Maria returns. Anna says, "A client called. I took a message." Maria says, "Thanks. I will call the client back after my meeting." Later, Maria tries to call, but the client is busy. She waits on hold. Then they speak, and at the end, they hang up. Maria tells John, "I will get back to the client tomorrow with the contract." At the end of the day, Carla in IT says, "The internet is slow. Please speak clearly on the phone." Everyone laughs because this is a typical day at the law firm. Today you practiced call back, on hold, hang up, speak clearly, take a message, get back to someone, and you also learned who works in a law firm: lawyer, secretary, paralegal, IT department. And you're doing great. And just to go over everything we learned quick, we practiced important job titles like lawyer, paralegal, and secretary. And we talked about the IT department and the legal departments in a law firm. We discussed subject pronouns like I, you, he, she, we, and they, and practiced the verb to be: am, is, and are. And finally, we studied useful telephone phrases like call someone back, on hold, and hang up. Keep practicing these words and sentences. They will help you communicate clearly and confidently in your legal English journey. When someone asks what you do, can you explain your legal job clearly in English? In this class, you'll learn how to talk about your daily work, describe your role in a legal office, and use the present simple to sound accurate and professional when introducing yourself or a colleague. This is part of our full legal English course for lawyers and legal professionals. If you want access to all the lessons, plus community support and practice, join us on our Skool platform. The link is in the description. Here's what you'll learn today. You'll practice how to describe your job, things like I answer phones or I help lawyers prepare documents. We'll learn job titles like assistant, paralegal, and receptionist. And we'll work with grammar, using the present simple to say what you do and what other people do. By the end of this class, you'll be ready to describe your legal work clearly and confidently. A legal assistant is a person who supports lawyers with both office work and some legal tasks. They answer phones, write letters, prepare legal forms, and help organize the lawyer's calendar. For example, Maria is a legal assistant. She schedules meetings and prepares files. Maria might also help draft simple documents or send emails to clients. She's not a lawyer, but she makes sure the lawyer has everything needed to work efficiently. An intern is someone, usually a student or recent graduate, who works in an office to gain experience. They may not get paid, but they learn a lot about the job by helping and observing. For example, Daniel is an intern at a law office. He is learning how to do legal work. Daniel might help organize files, observe client meetings, or do small tasks around the office. It's a great way to start a career in law or any other field. A clerk is someone who works with documents, records, and office organization. In a law office, a clerk might help with filing or organizing legal forms. In a court, a clerk helps the judge by managing the case documents. For example, the court clerk files documents and helps keep records. Imagine a courtroom. While the judge listens to the case, the clerk makes sure everything is recorded and in order. Without the clerk, the court would not run smoothly. A legal department is a team inside a company that deals with legal issues. They help the company follow the law, write contracts, and solve problems. For example, she works in the legal department at a big company. Let's say it's a bank and they're opening a new branch. The legal department makes sure everything is legal: permits, contracts, and employee rules. They don't work in a law firm, but they do important legal work inside the company. A court is a place where legal problems are solved. Lawyers, judges, and sometimes juries all work in the court. For example, the lawyer went to court to speak to the judge. Think of court like a special office where decisions are made. A court can be about criminal cases, family issues, or even business problems. It's where people go when they can't solve a problem on their own. A judge is the person who leads the courtroom and makes legal decisions. They listen to the facts, ask questions, and then decide what the law says. For example, the judge listened to the case and made a decision. Imagine a case where two people argue about a contract. The judge listens to both sides, reads the contract, and then decides who is right. Judges are experts in law and must be fair and careful. A client is the person or company who pays a lawyer for help. Clients can be people with problems or businesses needing advice. For example, our client asked for help with a family law case. Maybe a client wants a divorce needs a work visa, or has a business issue. Lawyers work to protect their clients' rights and explain the law clearly. A case is a legal problem that goes to court or needs legal help. It can be about crime, money, family, business, or immigration. For example, the lawyer is working on a criminal case. Every case has facts, documents, and goals. The lawyer studies the case, prepares arguments, and tries to win or solve the problem. It's the main unit of work in legal practice. To file documents means to put papers in order, in folders or on the computer or in a cabinet. For example, I file documents every morning. This is a common task in a law office. Say it with me. File documents. In the office, we often need to answer emails. We read and reply to messages from clients or coworkers. An example is, he answers emails in the morning. This is a common task for everybody, assistants, lawyers, and paralegals. Let's look at how we talk about what we do every day at work using the present simple. We use the present simple to talk about routines, things we do again and again. For example, I work in a law office. This is about you, your regular job. You help the lawyer. This is what you do. We file documents. We means me and my coworkers. This is a regular office task. They answer emails. This talks about other people, maybe the assistants or the team. There's no S at the end of the verb when we use I, you, we, or they. Let's say 4 sentences together. I work. You help. We file. They answer. Now, let's see what changes when we talk about another person. He or she. In English, we add S to the verb in the present simple when we talk about he or she. She answers the phone. He sends emails. She writes documents. So let's practice the pattern. He works. She answers. He sends. She writes. This S rule is very important. It's a small sound, but it shows you're talking about someone else, not yourself. Let's look at verb endings for he and she in the present simple. We just add S. She works, he helps, she files, he types. But when the verb ends in CH, SH, X, O, or SS, we need to add ES. Let's say these examples together. CH, he watches TV every night. SH, she finishes the report on time. X, the lawyer relaxes after court. Or O, she goes to court every morning. SS, he misses the deadline. This small change is very important. It helps your English sound correct and professional. Let's practice some real sentences together. You'll listen, then repeat. After each one, I'll tell you why it's correct. I file documents. Say it with me. I file documents. There's no S at the end. With I, we just use the base form of the verb. Next, he sends emails. Repeat. He sends emails. That's right. With he, we add S. Sends. Now, we answer the phone. Say it again. We answer the phone. Perfect. We is plural, so no S. Last one. She helps the lawyer. Together. She helps the lawyer. You got it. She gets the S. Helps. Now let's work on some legal phrases. Let's start with the common one. On the job. This means during your working hours, while you're doing work. For example, I answer emails and file papers when I'm on the job. You can say, he talks to clients on the job. She writes reports on the job. This is a simple way to describe when you do your tasks at work. Next is a useful phrase, day-to-day tasks. These are the small things you do every day, like answering the phone or checking emails. For example, filing documents and answering phones are my day-to-day tasks. It's a great way to explain your regular daily work. My day-to-day tasks include email, meetings, and reports. She manages the calendar as part of her day-to-day work. Now here's a fun idiom. Learn the ropes. It means to learn how a job works, especially when you're new. In my first week, I learned the ropes by helping a legal assistant. You can say, I'm still learning the ropes, or he helps new people learn the ropes. It's a friendly way to say, I'm getting used to the job. Let's learn another idiom. A lot on my plate. It means you are very busy. You have many tasks at work at the same time. For example, I have a lot on my plate this week. 3 meetings and a report. You can also say, she has a lot on her plate. She's helping 2 lawyers today. We all have a lot on our plate this month. This is great when you want to explain that work is busy. Let's finish with a wrap-up story, a day at the office. Let me tell you a little bit about my day at the office. I'm a legal assistant. I usually start on the job around 8 a.m. My day-to-day tasks include answering emails, filing documents, and helping the receptionist when the phone is busy. I also support the lawyer. I print documents and schedule meetings. I'm still learning the ropes, especially with the legal software and how to organize files the right way. And this week, I have a lot on my plate. A report to finish, 3 client emails to send, and some new training. It's busy, but I enjoy it. And now you can describe your legal job too, in clear, simple English. Before we finish, let's review what you learned today. First, you learned important legal job words like lawyer, paralegal, receptionist, and legal assistant. These will help you talk about jobs in a law office. You practice common office tasks like answer emails, file documents, and help the lawyer. We also studied present simple grammar. Remember, no S with I, you, we, or they, but add S or ES with he and she. And finally, you learned useful idioms to describe your workday. On the job, day to day, learn the ropes, and a lot on my plate. Great job today. Keep practicing, and soon you'll be talking about your legal job with confidence. We know learning legal English as a beginner is difficult. You can join our school group for easy lessons, live webinars, and a supportive forum, and start speaking legal English confidently. The link is in the description. As a legal professional, first impressions matter. But how do you start a conversation when you're not sure what to say? In this class, I'll show you the simple phrases lawyers use to break the ice, build rapport, and sound friendly and professional from the very first moment. This is part of our full legal English course for lawyers and legal professionals. If you want access to all the lessons, plus community support and practice, join us on our Skool platform. The link is in the description. Here is what you'll learn in this class: how to greet people politely, like, nice to meet you. How's your day going? How to start a friendly conversation at work. We call that small talk. You'll also learn how to talk about everyday topics like your daily routine. And we'll practice asking and answering simple questions using the present simple. Questions like, do you work here? What time do you start? All in clear, simple legal English. Let's start with a warm up. Here are some examples of small talk, short, friendly conversations people use at work. For example, good morning. How are you today? How is your family? Do you have a busy day ahead? How was your weekend? These questions are polite, simple, and help you build good relationships with your coworkers and clients. Let's start with two simple and polite greetings: good morning and good afternoon. We say good morning before 12 p.m. and good afternoon after 12 p.m. These phrases are common in legal offices. For example, good morning, Mr. Lee. How are you today? Try it. Good morning, good afternoon. When you meet someone for the first time, you say, nice to meet you. It's polite and professional. For example, hello, I'm Ted. Nice to meet you. Say it with me. Nice to meet you. It's a great way to make a good first impression. Here is a common question: how are you? It's small talk. It shows interest in the other person. You can use it with clients, coworkers, or visitors. For example, hi, Anna. How are you today? Say it with me. How are you? Let's practice a common small talk question. How is your family? You can use this with coworkers or clients to be friendly and polite. For example, hi, Anna. How is your family? It's simple and kind. Do you work here? This is a great conversation starter. You can use it when you meet someone at the office or in the hallway. For example, hi, I'm new. Do you work here? Repeat. Do you work here? And finally, here's another useful question about someone's routine. What time do you start? For example, what time do you start work in the morning? This is great for casual conversation with a coworker. What time do you start? Let's practice some greetings. I want you to match the phrase to the situation. Which one fits each moment? Number one, you meet someone for the first time. The answer is B, nice to meet you. Number two, you arrive to work at 9 a.m. That's A, good morning. Number three, you start a friendly conversation. Yes, it's C, how are you? Say each one with me. Good morning. Nice to meet you. How are you? Great job. Let's learn how to ask basic yes no questions in English using the present simple. To make these questions, we use do or does. depending on the subject. Use do with I, you, we, and they. For example, do you work here? Do they speak English? Use does with he, she, and it. For example, does he drive to work? Does she live nearby? Notice that the main verb stays the same in the base form. Not does she lives, but does she live? Here are some more examples. Do you speak English? Yes, you do. Does he work at a law firm? Do they have a question? You're doing great, and these questions are very useful in legal and professional conversations. Let's continue learning how to ask WH questions in English. The questions that start with what, where, when, why, and who. These words ask for different kinds of information. What asks about things. For example, what do you need? Where asks about places. Where do they live? When asks about time. When does she arrive? Why asks about reasons. Why do you want to speak to the lawyer? Who asks about people. Who do you work with? The structure stays the same. The WH question word plus do or does plus the subject plus the base verb. Here are two new ones to practice. Why do you want to speak to the lawyer? Who do you work with? You can use these questions at work, in emails, or in meetings. They're polite, professional, and simple. Let's talk about when to use do and when to use does in WH questions. It's very simple. Use do with these subjects I, you, we, and they. Use does with he, she, and it. Let's look at some examples. Where do you work? You, so we use do. Why do they need a lawyer? They, so we use do. Now with does. What does he want? He, so we use does. When does she arrive? She, so we use does. And remember, after do or does, we always use the base form of the verb. So this is incorrect. What does he wants? No, we say, what does he want? This small grammar rule will help you ask professional, correct questions every time. Now, let's learn how to change a sentence into a question, a yes no question. Look at this example. The statement, you work here, that's a regular sentence. Now, let's turn it into a question. Do you work here? We simply add the word do at the beginning. That's the trick. So we go from you work here to do you work here? And how do we answer? Yes, I do, or no, I don't. Now, let's learn how to ask a WH question. Here's a normal sentence. You start at 8:30. That's a fact. Maybe you're talking to a coworker. Now let's turn that into a question. What time do you start? We add a question word at the beginning. Here it's what time? Then we say, do you start? Let's say it together. What time do you start? I start at 8:30. So remember, you start at 8:30 is the statement. The question is, what time do you start? Excellent work. Let's move on to phrases. Let's start with something you'll hear every day. How's it going? It's an informal way to say, how are you? For example, hi, Sophia. How's it going? You can use this with coworkers or clients when you want to be warm but professional. Try saying it with me. How's it going? Next phrase, nice to see you. When you meet someone you've seen before, you say, nice to see you. It's simple, polite, and friendly. For example, nice to see you again, Mr. Cruz. Use this at the start of meetings or calls. Say it with me. Nice to see you. Not too bad is a very common reply when someone asks, how are you? That means, I'm okay. Not great, not terrible, just fine. For example, how are you? Not too bad, thanks. It's casual and friendly. Repeat after me. Not too bad. Same here is an easy way to say, me too. For example, I had a busy morning. Same here. It's short and useful in conversation when you want to agree quickly. Say it with me. Same here. Now the idiom break the ice. Break the ice means to start a conversation and help people feel more relaxed. In law offices, small talk helps break the ice with clients. So say it with me. Break the ice. Now, let's match the phrase to the meaning. So you feel okay, not great, not bad. D is the correct answer. Not too bad. You want to say, me too. That's B, same here. You want to start a friendly conversation. That's break the ice. You greet someone you already know. It's A, nice to see you. Excellent job. Let's take a moment to review everything you learned today. First, you practice polite greetings, the kind of language we use when meeting someone at the office or on a call. You also learned how to start small talk with clients and coworkers with questions like, how's it going? And simple conversations about daily life. We practiced talking about routines, what people do at work, using present simple grammar. You learned how to ask and answer yes no questions like, do you work here? And WH questions like, where do you work? Or why are you here? And finally, we looked at easy everyday idioms like, how's it going? Break the ice to help you sound friendly and natural in professional English. You did a fantastic job. Keep practicing, and legal English will become easier every time. And we know that learning legal English as a beginner is difficult. You can join our Skool group for easy lessons, live webinars, and a supportive forum, and start speaking legal English confidently. The link is in the description. Hi there. Welcome to your first intermediate legal English class. Today's lesson is all about professional legal communication, specifically how to introduce yourself in a networking setting. This is something every lawyer needs to do, and we're going to make sure you sound clear, confident, and professional when you do it in English. Let's get started. Today, we'll focus on three main goals. First, use appropriate vocabulary to introduce yourself and talk about your legal work. Second, ask and respond to questions about your role and experience. And third, practice professional conversations for networking. By the end of this lesson, you'll feel more confident introducing yourself and discussing your legal background in English. Let's warm up with something simple. Imagine you've just walked into an event, maybe hosted by your bar association. You're holding a drink, scanning the room. Someone comes up next to you and says, "Hi, I'm Anna. I work in labor law. What about you?" Now, what do you say? So here's a simple structure to help you. You can start with, I'm a, your job, based in, your location. Or, I work in your practice area, law, mostly handling your responsibilities. This gives people a clear idea of who you are and what you do without too much detail. It's just enough to open the door to a deeper conversation. So before we move on, think for a second. How would you respond to Anna using this structure? Let's try again a little bit later and I'll show you a few examples. Here's a great example of how to introduce yourself. I'm a corporate lawyer based in Colombia. It's short, professional, and tells the listener exactly what you do and where you're based. Think about how you might say something similar. What kind of law do you practice? Where are you located? For example, I practice immigration law. I'm based in Costa Rica. Now let's look at another one. I work in compliance for a fintech company. This is useful because it includes both your legal focus, compliance, and the type of company you work for. When you're networking, giving just a little extra context like this can really help people understand your role. Here's a different kind of introduction. I run my own immigration law practice. This tells us you're self-employed and your area of law. It's clear, confident, and it opens up the door for follow-up questions. So take a moment. How would you describe your role in one sentence? When you're introducing yourself as a lawyer, it's important to be specific about your work. This phrase is very useful. I specialize in. Tells people what your main area of law is. It shows your expertise. For example, I specialize in family law. I'm currently working on. Helps you explain what you're doing right now. You could say, I'm currently working on a real estate development deal. These are clear and professional, perfect for networking. I handle. I handle is a great way to describe your day-to-day responsibilities. It's simple and flexible. You can say, I handle compliance for a logistics firm. I've been working with is perfect for talking about long-term work. For example, I've been working with government clients since 2019. These phrases help you sound experienced and confident, but still natural. Finally, let's talk about location. I'm based in is a common phrase when you're introducing yourself professionally. You might say, I'm based in Lima, but often work remotely. This is especially helpful if you work internationally or collaborate across borders. Simple, clear, and professional. All right, so let's take a moment to check your understanding. You've seen these phrases a few times already. Now let's match them to their meanings. Here are the phrases. I specialize in, I'm currently working on, I handle, I've been working with, I'm based in. And here are the possible meanings. My current case or project. B, my responsibilities. C, my location. D, my legal area. And E, my long-term experience. So take a moment and try to match them. You can pause the video here if you want to think it through. No pressure. All right, let's get into it. Let's go through the answers together. Number 1, I specialize in. That's D, my legal area. You use this when you're talking about the area of law you focus on, like family law, real estate law, human rights law. I'm currently working on. This one is A, my current case or project. It's useful when you want to mention something you're doing right now, like a trial or negotiation. I handle. That goes with B, my responsibilities. It describes the kind of tasks or cases you're usually responsible for, like contracts, litigation, client intake. I've been working with. This matches with E, my long-term experience. In my case, I would say, I've been working with asylum seekers for over 7 years. Finally, I'm based in, and this is C, my location. It's a simple way to say where you live and work. These phrases are great for making a small talk sound professional. They're short, clear, and tell people a lot about you without needing a long explanation. We'll keep practicing these, so don't worry if they're not automatic yet. It's your turn to put the phrases into action. Take a look at these 5 sentences on the screen. Each one is missing a key word or phrase we practiced earlier. Let's see how well you can complete them. Number 1, I blank an international arbitration. 2, I'm currently blank a data privacy case. Or 3, I blank commercial contracts and compliance. 4, I've blank NGOs since law school. And last, I'm blank in Mexico City. Pause the video here if you want a moment to think. Try saying your answers out loud. This helps you remember and speak more confidently later. Let's go through each one. Number 1, I specialize in international arbitration. This tells someone your specific area of legal focus, a great phrase to use in introductions. I'm currently working on a data privacy case. This is useful when you talk about what's happening in your day-to-day work right now. I handle commercial contracts and compliance. Here, you're talking about your usual job responsibilities, what falls under your role, what you have to do. I've been working with NGOs since law school. This one highlights your long-term experience. Great for building credibility when networking. I'm based in Mexico City. Simple and professional. It lets people know where you work without needing to explain more. If you got this right, great jobs. If not, no worries. We'll keep practicing these throughout the lesson. Repetition is definitely key. Let's start with this sentence. I work as a legal advisor for a real estate firm. This is the present simple, and we use it to talk about what we do right now. So if someone asks you at a networking event what you do, you can simply say, I work in criminal defense, or I work in corporate law. Easy, right? Now, let's take a look at this sentence. I've been working as a legal advisor since 2018. This is present perfect. We use it to talk about how long we've been doing something. So if someone asks, how long have you worked in this field? You might say, I've been working in that area for 6 years. And you can try it with your own job. Let's compare the two side by side first. First, we have the present simple. I work in environmental law. It's short, clear, and tells people what you do now. Next, the present perfect. I've been working in that field since 2020. This adds more detail, how long you've been doing it. And here's a trick. When networking, use both. Start by saying what you do, then add how long. For example, in my case, I work in immigration law. I've been working in that area over the past 8 years. It's natural, it's fluent, and it shows your experience without sounding like a resume or CV. Want to try saying your version? I'll give you a moment. All right, let's cut to the chase. It's time to explore one of the most useful idioms in legal English. You'll hear this phrase a lot in busy legal settings, especially during meetings or calls where everyone's short on time. It means let's skip the small talk and get right to the important issue. You can use it when you want to move the conversation forward quickly. And here's how it sounds in action. Let's cut to the chase. What does the client actually want? Notice the tone. It's not rude, just direct. In fact, in legal work, being concise and focused is often appreciated. So next time you're in a client meeting or negotiating with another lawyer and things are dragging on, try saying, let's cut to the chase. It's a professional way to take control of the conversation. Just be sure the context is right. Especially in some cultures, indirectness is preferred. So let's try saying it one more time together. Let's cut to the chase. So great. Now keep an ear out for it in your next legal meeting, client meeting, and we're going to go to the next one, which is, that's a gray area. This idiom comes up a lot in legal work because, well, law is not black and white. In many situations, it falls into what we call a gray area, a space where things aren't clearly defined and there may be no specific rule or clear answer. So you might hear a lawyer say, This law is a gray area. There's no clear regulation yet. It's a useful way to explain uncertainty or a legal loophole without sounding unsure of yourself. It signals nuance, that things are open to interpretation. Try using it when you're discussing a legal question that has more than one reasonable answer, or when advising a client when the outcome isn't totally predictable. So let's try saying it. That's a gray area. Let's move on to the next one. Let's talk about the phrase walking on thin ice. Have you ever had a client who's unhappy, a judge who's impatient, or a project, case where one mistake could blow the whole thing up? That means you're walking on thin ice. This idiom means you're in a risky situation. One wrong step and things could go very badly. It's a vivid, clear way to express caution and alert others that things are fragile. Here's an example. We're walking on thin ice with this client. We can't afford another mistake. This idiom is especially useful if you want to use it with someone in a professional way without sounding too dramatic. Use it to flag risk or when you want to gently suggest, let's be careful here. So let's practice it one more time. We're walking on thin ice. Let's go ahead to the classic one. Very common law. Playing devil's advocate. This idiom is especially relevant in the legal world. To play devil's advocate means to intentionally argue the other side of an issue, even if you don't personally agree, just to test the strength of an argument or uncover weaknesses. For example, he's just playing devil's advocate. He doesn't really disagree. This is a great tool in legal conversations, especially when you're preparing for a trial, writing a memo, or coaching a client. It shows strategic thinking. You're not just defending your own position, you're pressure testing it. So if someone in your legal team starts challenging your idea out of nowhere, don't panic. They might just be playing devil's advocate. Say it with me. She's playing devil's advocate. Perfect. We've got 3 great idioms under our belt. Now, let's talk about a simple way to introduce yourself in a professional setting. It's called the networking formula. This formula helps you quickly communicate who you are, what you do, and what makes you unique, all in 1 or 2 smooth sentences. Here's the structure. Location plus role plus focus area plus experience. So let's break that down. Location, where are you based professionally? Role, what is your current job or title? Focus area, what area of law do you work in? Experience, what's your background or expertise? Here's an example using the formula. I'm based in Lima. I work as a compliance attorney. I specialize in data protection. I've been working with fintech companies for 5 years. That's a clear, confident way to explain your professional profile without overthinking it. It sounds natural and informative, perfect for networking events. Now, try thinking about your own version. Where are you based? What's your role? What area do you focus on? And what's something impressive or unique about your experience? If you want, you can pause the video and write it down. So you've got your formula ready. Practice saying it out loud a couple times. It'll help you sound smooth and prepared when it counts. All right, let's wrap up today's lesson on preparing for networking events. Today, you practice some really useful skills for making a strong first impression in professional settings, especially when English isn't your first language, but you want to sound confident and clear. Let's take a moment to review what we've learned so far. We've learned how to introduce yourself professionally in English with simple, clear sentence structures you can use in any legal sentence, from bar association mixers to international conferences. You practice using key phrases like I handle, I specialize in, and I'm currently working on. These are essential for talking about your role and responsibilities in a way that sounds natural and professional. You've reviewed grammar differences between the present simple and present perfect, so you can talk about your current job and your long-term experience with confidence. And you explored professional idioms that lawyers actually use in conversations, like let's cut to the chase, that's a gray area, and of course, devil's advocate. Hi, and welcome to another legal English lesson for lawyers. I'm Ted Goodman, and today we're diving into a core professional skill: how to give legal advice clearly, confidently, and in a way your clients can actually understand. Whether you're helping a startup, advising on immigration, or managing litigation, knowing how to explain legal issues in plain, professional English is key. Let's take a quick look at what we'll cover in today's lesson. First, we'll explore some of the most common phrases lawyers use when advising clients. These expressions will help you sound professional but approachable. Second, we'll use modal verbs like should, might, and must so you can offer legal recommendations clearly and accurately. Third, we'll look at some polite legal idioms that can help you soften your tone when necessary, especially when discussing risks and obligations. And finally, you'll be practicing responding to a common client questions using professional language that builds trust. And by the end of this lesson, you'll be much more confident speaking with clients, whether you're in a call, writing an email, or meeting face to face. Let's start with a warm up to get you thinking. What do clients really expect when they come to a lawyer for advice? In most cases, they're not looking for complicated legal theory or overly technical language. They want clear, helpful guidance. Let's break it down. First, honesty and clarity. Clients need to trust you. They appreciate it when you explain things in plain English. No jargon, no legalese, no confusion. Second, they want a step by step explanation. The legal process can be overwhelming. When you guide them through it clearly, you build confidence and reduce stress. Third, clients want to know their options. What choices do they have? What are the risks? And what might happen next? Giving them realistic outcomes helps them make smart decisions. So take a moment now, if you want to pause the video and think about your own experience. What kind of expectations do your clients usually have when they meet with you? You can write a few ideas down, then hit play when you're ready to continue. Let's begin looking into some vocabulary. Let's start with the verb counsel. In legal English, to counsel someone means to give advice, formally and professionally. Instead of saying, I give advice to clients, you might say, I counsel clients on their legal rights. It's a more precise, professional sounding verb that shows you're speaking in a legal context. For example, our firm counsels startups on regulatory compliance. Try using this in a sentence about your own work. How do you counsel clients? Next up is a key legal term: legal standing. This means a person has the right to bring a case to court, that they're directly affected by the issue. For example, we could say the plaintiff had no legal standing to sue. That means the courts didn't recognize their right to take legal action. No standing, no case. You'll hear this term often when discussing access to justice or procedural issues. Let's talk about a very important word: liability. It's a word you'll use often in civil law. Liability means legal responsibility. If someone is liable, they're legally at fault. An example: the company accepted liability for the damage. This shows up frequently in lawsuits, insurance claims, and tort law. Keep it in mind anytime you're discussing who's responsible for harm or loss. In common law systems like the United States and UK, precedent is a big deal. It means a prior court decision that sets the standard for future cases. Judges often say things like, we followed precedent from an earlier case. Using precedent helps keep legal decisions consistent and fair. When advising clients, it's helpful to explain how past cases can affect their outcome. Compliance. Compliance is all about following the rules. In legal terms, it means obeying laws, policies, or official procedures, especially in business and regulatory law. For example, the company was in full compliance with regulations. You'll hear this term in contexts like internal audits, corporate governance, or risk assessments. Staying in compliance helps companies avoid legal trouble. All right, let's take a moment to check your understanding so far. We've been using these legal terms. Now, let's match them to their meaning. Here are your terms: counsel, legal standing, liability, precedent, compliance. And here are the possible meanings: legal responsibility for something, a previous decision that guides future cases, to give professional legal advice, the right to bring a legal case, following legal rules or standards. So take a moment and try to match them. Feel free to pause the video and think about it. No rush. Okay, ready to check? Let's walk through them. Counsel. That's C, to give professional legal advice. So instead of saying give advice, we say counsel a client. Sounds more professional, right? Legal standing. That's D, the right to bring a legal case. If someone doesn't have a legal standing, they can't file a lawsuit. Liability goes with A, legal responsibility. Think of civil cases where someone's found liable for damages. And precedent, that one's B, a previous decision that guides future cases. It's a big deal, like we talked about in common law systems like the US and UK, as well as international courts like the Inter-American Court for Human Rights. Last one, compliance, and that's E, following rules or regulations. Businesses talk about this all the time. Being in compliance with the law. If you got them all, great. If not, don't worry. We're going to keep using these terms so they feel more natural with practice. Now, let's take that vocabulary and actually use it in some real world context. You'll see 5 sentences, and there are 5 words to choose from. Again, counsel, legal standing, liability, precedent, and compliance. Go ahead and pause the video for a second and try to fill in each blank. All set? Let's go through the answers together. The judge ruled that the plaintiff had no legal standing to sue. That means they didn't have the legal right to bring the case in the first place. Our firm must ensure full compliance with data protection laws. Super common in corporate law and regulatory law. It just means follow the rules. The attorney offered clear counsel on the client's next steps. That one's straightforward. Counsel is a professional way to say advice. This case could set an important precedent for future lawsuits. This is what happens when one court's decision influences other similar cases. The company accepted liability for the damages caused. That means they're taking responsibility, legal responsibility, for what happened. So, how'd it go for you? If you got them all, great work. If not, that's why practice makes perfect. So, just hearing and using terms like this will help you get more confident over time. Now, let's take a look at some common modal verbs you'll hear when giving legal advice. We use should when we want to recommend something. For example, you should speak to a lawyer. Must is stronger. It shows legal obligation, like tenants must pay rent on time. Might suggests something is possible, but not certain, like the court might reject the evidence. Can is used for general possibility or ability, as in we can request an extension. And finally, could is great for polite suggestions. For example, you could include a disclaimer. Try listening for these modals the next time you read legal emails or documents. They're everywhere. All right, let's talk about really common idioms in legal and business conversations. First one, cover your bases. This just means to be careful and make sure you've protected yourself. You're checking all the details, thinking ahead, making sure nothing gets missed. So, if a lawyer says we reviewed every clause to cover our bases, it means they're being thorough, trying to avoid surprises later. It's a great idiom to use when you're talking about playing it safe. Next up, in hot water, one you want to avoid, and probably you've heard this one before. If someone is in hot water, it means they're in trouble, and not the small kind. Usually it's serious and often legal, like in this sentence. The company is in hot water for violating the contract. This idiom pops up a lot in the news when a company or a public figure is facing legal action or public backlash. This one has a similar tone to it. On thin ice. If someone is on thin ice, it means they're in a risky situation, they've made a mistake or pushed the rules, and now they're close to getting into trouble. For example, the witness is on thin ice after lying under oath. It's like saying, you better be careful, one more mistake and you're in real trouble. We use this a lot when someone's actions have put them in a dangerous spot legally. All right, here's one that I definitely get frustrated with. I know fellow lawyers do too, as well as clients. Red tape. This means bureaucracy. All the paperwork, procedures, and delays that slow things down. You'll hear people say things like, there's a lot of red tape in the visa application process. So, if you've ever felt stuck dealing with forms, approvals, or confusing rules, that's red tape. And last idiom for today, letter of the law. This idiom means applying the law exactly as it's written. No flexibility, no interpretation, just what the words say. So when someone says the judge followed the letter of the law, they're pointing out that the judge made a strict technical decision, even if it feels unfair sometimes. It's a great phrase when you want to talk about how strictly or flexibly the law is applied. All right, now we're going to look at two really important grammar tools that come up all the time when you're advising clients. First conditionals and modals. First conditionals are great for talking about possible future situations and their results, like if this happens, then that will happen. Modals, on the other hand, like you've seen, help us express advice, obligation, possibility, or permission in a clear and professional way. So, understanding the difference between these two will help you give advice that's precise and easy for clients to understand. Let's break down each one so you can see how to use them effectively in your conversations with clients. Let's dive into first conditionals. A first conditional talks about a real or likely situation in the future and what will happen as a result. It follows a simple pattern. If plus present tense, then will, might, or can plus the base verb. For example, if the tenant breaks the lease, they might lose their deposit. This structure helps you clearly explain consequences to your clients so they know what could happen depending on their choices. It's very useful in legal advice because clients often need to understand cause and effect in their cases. Now, let's go over modals again because they're so important. Like we've heard, should, must, might, can, and could. They help us talk about advice, explain obligations, or talk about possibilities. And they show how strong or polite your advice is. For example, you've heard this one before. The tenant should read the contract carefully. This is polite but clear, and it's a recommendation. So, using modals makes your advice sound professional and precise, which is exactly what clients need. So, here's a simple way to keep first conditionals and modals straight. Think about what you want to focus on. If you want to focus on a clear cause and effect, like what will happen if something occurs, then that's when you use a first conditional. But if you're more focused on how to give advice, the tone, the strength, the level of risk, then modals are your go to. Those are what you should use. So, first conditionals, is for cause and effect. Modals is for tone and advice. So keep that in mind, and you'll sound really clear and professional when talking to clients. All right, to wrap things up, here's a quick tip to practice. Use a first conditional when you want to explain what might happen next, like a possible outcome. For example, if the contract is unsigned, the deal won't be valid. But when you're giving advice or stating rules, modals are the way to go, like you must sign before the deadline. So remember, first conditionals for what could happen and modals for what someone should or must do. Keep practicing this, and it'll soon feel natural when you're advising clients. And before we finish, let's just pause for a moment and talk about tone, which is so important when giving legal advice. It's not just what you say, but how you say it that matters. Clients want clear guidance, but they also want to feel respected and like they're making their own decisions. And that's where the modal verbs like should, might, and could really help. They soften your message, making your advice sound professional, but not too pushy or demanding. So instead of saying you must do this, you might say you might want to consider this option. So remember, good legal advice is all about balancing clarity with tact. And here's the key insight I want you guys to remember. The way you phrase advice really shapes how your clients feel and how they respond. If you use polite, flexible language, clients usually feel more comfortable. They feel like you're guiding them, not bossing them around. And that builds trust, which is huge in legal work. But if your tone is too forceful or harsh, they might shut down, get confused, or even push back. So always ask yourself, how does this sound to the client? Legal advice isn't about giving orders, it's about helping people feel confident and supported. All right, nice work today. We covered some really important tools for giving legal advice. You practice modal verbs like should, must, and might. Also, we talked about first conditionals, great for talking about consequences. And remember that it's great when you talk about consequences. For example, if this happens, then that might happen. And most importantly, we talked about tone and how to sound clear and professional without being too harsh. Because clients don't just want legal answers, they want to feel supported and understood. So keep practicing these, and they'll make a big difference in how you communicate with clients. Welcome back to Intermediate Legal English. Today we're focusing on something many lawyers find tricky: telephone communication. Unlike email or in person meetings, phone calls give you no body language, no facial expressions, and very little time to prepare. But for lawyers, phone communication is essential. Clients call with urgent questions, court staff follow up on cases, and opposing counsel might ring you without warning. So, in this class, we'll practice how to answer professionally, state your purpose clearly, transfer or hold the call politely, and sound confident, even when the conversation is fast or unexpected. Let's get started. Here's what you'll learn in today's class. First, how to greet clients, judges, or opposing counsel when a call begins, and sound calm and professional. Then, we'll look at how to explain the purpose of your call and ask questions when you're not sure who you're speaking to or what they need. Next, we'll work on vocabulary for putting someone on hold or transferring a call, which is especially useful for law offices and firm receptionists. Finally, we'll cover two grammar tools that often come up on the phone: reported speech and question intonation. Both help you sound polite, clear, and confident. Let's start with a quick warm up. What makes legal phone calls more challenging than casual ones? Think about it. When you're on the phone, you can't see the person, so you miss gestures, facial expressions, and cues. You rely entirely on tone and words. The speech might be fast, especially if someone's in a rush or stressed. The vocabulary is often formal, and sometimes you have to switch between speakers or departments, or even take notes while listening. So today, we're going to build your confidence in handling these challenging step by step with phrases, grammar, and world practice. Let's start with the phrase you'll hear in nearly every law office. Hold the line. This means wait on the phone and don't hang up. For example, could you please hold the line while I transfer your call to the attorney? Picture this. A receptionist answers the phone. A client wants to speak to a lawyer, but the lawyer's in a meeting. So the receptionist says, "One moment, please. Could you hold the line?" It's a polite, professional way to ask someone to wait, and it's much better than saying, "Wait." Next up, put through. This phrase means to connect someone's call to another person or department. For example, "I'll put you through to Miss Lopez in legal services." In law firms, this is common. Someone calls the main line, but they need a specific lawyer. The receptionist doesn't just say, "Wait, I'll transfer you." They say, "I'll put you through now." It's simple, polite, and professional, and shows you know legal office etiquette. "May I ask who's calling?" This one's about tone and politeness. "May I ask who's calling?" means a polite way to ask for someone's name. For example, "Certainly. May I ask who's calling, please?" Instead of saying, "Who is this?" which can sound rude or suspicious. Lawyers and staff use this polite form. Let's say a client calls and says, "Hi, I need to speak to someone about my case." You respond, "Of course. May I ask who's calling?" It keeps the tone calm, respectful, and professional, even if you're not sure who they are. Next one. "I'm afraid he's unavailable." This means the person can't take the call right now. For example, "I'm afraid Mr. Johnson is unavailable right now. May I take a message?" Why say "I'm afraid"? It softens the message. It's not about fear, it's about politeness. A client calls and asks for a lawyer who's in court. You could say, "He's not here," but it's much more professional to say, "I'm afraid Mr. Johnson is unavailable at the moment." It shows courtesy, even when delivering bad news. The purpose of your call. This is all about clarity. It's the reason someone is calling. For example, could you please tell me the purpose of your call? Let's say the phone rings and the person says, "I need help with the case." You don't know who they are or what they want. So you politely ask, "Of course, could you please tell me the purpose of your call?" This helps you direct them to the right department and keeps the call focused and efficient. This one, self-explanatory. "I'll call you back." So this means you'll simply return the call later. For example, you could say, "I don't have that information now, but I'll call you back as soon as possible." In legal practice, we don't always have answers right away. A client might ask about a case and need to check a file or speak with a colleague. Instead of leaving them waiting, say, "Let me confirm that, and I'll call you back this afternoon." It shows professionalism. It shows professionalism and gives the client the confidence that you'll follow through. Let's practice using the vocabulary in a real situation. You answer the phone and someone says, "Hi, I need to speak to Attorney Morales." What should you say? Here's one professional response. "I'm afraid Miss Morales is unavailable at the moment. Could you please tell me the purpose of your call?" You've used two key expressions. "I'm afraid she's unavailable," which is polite and respectful, and "the purpose of your call," helping you direct the client properly. Then, depending on the reason, you might say, "Please hold the line. I'll put you through to her assistant." Short, polite, and efficient. Exactly what you want on a professional call. Here's a multiple choice practice. What's the professional response? A client says, "Can I speak with someone about a real estate case?" Let's look at your options. A, "Wait a minute, I'll see who's free." Sounds a bit too casual. B, "Hold on, I'm transferring now," is better, but still too abrupt. I think the best option is C. "Certainly. May I ask who's calling and the purpose of your call?" This response is polite, clear, and professional. It helps you identify the caller, understand their needs more clearly, and direct the call properly, just like you would in a real law office. Let's try another one. A client calls and asks, "Is Mr. Davis available?" Here are your choices. A, "No, he's not here." That's too blunt and not very professional. C, "He's busy, call back later." Also, a little rude and not helpful. Let's go for me. The best answer is B. "I'm afraid he's unavailable right now. May I take a message?" It's polite, respectful, and offers a solution. Remember, even when someone's unavailable, the way you respond reflects on the whole firm. Final one for now. And this one's about making a professional transfer. You're on the phone and need to send a call to Attorney Zhang. What do you say? A, "One sec, I'm moving your call." That's too casual, especially using 1 sec instead of 1 second. C, "Just wait. No explanation, no courtesy." For me, the best answer is B. "I'll put you through to Attorney Zhang in litigation." It's direct, polite, and professional. Clients don't just want speed, they want clarity and care in how you speak. Let's look at reported speech, which is often used when taking or delivering messages in legal calls. For example, a client says, "I need to speak to my lawyer." You don't quote them word for word. Instead, you report what they said. For example, the client said she needed to speak to her lawyer. Or if a judge says, "Please call me back before 3 p.m., you might tell your colleague, "The judge asked us to call her back before 3 p.m. Notice how the verbs change. Need becomes needed. Ask becomes asked. This style is more professional and common when relaying messages. Let's practice some real-world reporting. Your colleague asks, "What did the client say?" Here's what the client said on the phone. "I signed the contract yesterday." You say, "She said she had signed the contract yesterday." Next one. "My court date is on Tuesday." You say, "He said his court date was on Tuesday." "I can't speak to the other party." You say, "She said she couldn't speak to the other party." See how we shift the tense? This kind of grammar is everywhere in legal communication, especially when delivering accurate messages. Let's talk about intonation, the rise and fall of your voice when speaking. Look at these two sentences. You're calling about the contract. You're calling about the contract? The first sounds like a statement, but the second, with that rising tone at the end, becomes a yes-no question. In English, yes-no questions usually rise at the end. WH, like who, what, when, like what time did you call questions, usually fall. Getting this right helps you sound confident and natural, especially on the phone, where your tone is your main tool for communication. Let's test your intonation and tone. A client says, "I have a question." Which sounds most polite and professional? A, "What do you want to ask me?" Too direct. Sounds impatient. "You have a question?" That rising intonation is confusing. It sounds doubtful. For me, the best answer is C. "Could you tell me what your question is, please?" It uses a soft tone, polite phrasing, and neutral intonation. In legal communication, especially over the phone, how you say things matters just as much as what you say. Now, my favorite part of the lesson, legal phrases and idioms. Get back to someone. Let's start with a very useful one. Get back to someone. This means to respond later to a phone call, email, or request. For example, I don't have that information now, but I'll get back to you by the end of the day. In legal work, you can't always answer a question immediately, but you can keep communication professional by saying, let me check that, and I'll get back to you shortly. It shows you're reliable and that you respect the client's time. Here's a good idiom, touch base. This means to make quick contact, to check in, follow up, or share a brief update. For example, I'm calling to touch base on your upcoming court date. It's less formal than follow up, but still professional. Lawyers often use it to keep clients informed without sounding too stiff, too formal. I just wanted to touch base about your case and let you know we received the court notice. Another phrase, put someone on speaker. This means to switch the call to speakerphone so other ones in the room can hear. For example, let me put you on speaker so my colleague can hear this too. In legal meetings or team calls, this comes up all the time, especially during client consultations or multi-party calls. Always tell the person before you do it though, because confidentiality matters. For example, is it okay if I put you on speaker? I'm with the litigation team now. For the record, here's a phrase with legal weight. It means you want something to be officially stated or remembered. For example, for the record, I did return the client's call yesterday. It is often used in court, but also in firm communication, especially when there's a disagreement or miscommunication. For example, for the record, we contacted the opposing counsel 3 times before the deadline. It signals that the information matters and might need to be written down or repeated. The last phrase, hang up on someone. Here's a less polite phrase, but it's important to understand. You hang up on someone. It means to end a phone call suddenly without saying goodbye. So, for example, the client was frustrated and hung up on the receptionist. In legal work, this might happen when someone's angry or stressed, and of course, the key is to stay calm and respond professionally. You could say, for example, oh, it seems the line was disconnected. I'll follow up by email. You don't accuse, you just stay composed and keep the communication moving forward. And let's do one more actually. Patch someone in. So, patch someone in, it means to connect another person to the same phone call. For example, I'll patch in Attorney Rojas so we can speak together. You'll use this when calls go from one-on-one to group calls. Always tell the caller what's happening. For example, one moment, I'm going to patch in my colleague who's handling the litigation. It keeps the client informed and maintains professionalism. Let's bring it all together with one final story, a common scene in any law office. It's 3:45 p.m. and Sophia, the junior associate, returns from court. As she walks into the office, the receptionist says, for the record, Attorney Gomez from the opposing firm called earlier. He said he needed to confirm a filing deadline. Sophia replies, did he leave a message? The reception nods. Yes. He'll get back to you by 4:30. I told him you were unavailable, but that I'd let you know as soon as you returned. Sophia checks her notes and says, perfect. I'll touch base with him now. She picks up the phone and dials. When Attorney Gomez answers, Sophia says, hi, this is Sophia Morales from Rivera and Cruz. I'm calling to follow up. I understand you had a question about the deadline. He replies, "Yes, I wasn't sure if the deadline included weekends." Sophia responds clearly, using a polite, rising intonation. "Would you like me to check with the clerk and get back to you in a few minutes?" He agrees. She hangs up, makes a quick call, and then follows through, just like she promised. Sophia then calls Attorney Gomez again and says, "Thanks for holding the line earlier. I've confirmed with the court. Weekends are excluded. You're good through Monday." It's a simple story, but it shows you everything we practiced today: professional vocabulary, courteous tone in question forms, clear use of reported speech, and legal phrases like "get back to you," "for the record," and "touch base." It's not about being perfect, it's about being clear, calm, and confident. Before we wrap up, let's review what we practiced today. You learned essential vocabulary for legal phone calls, terms like hold the line, unavailable, and put through. All phrases you'll hear every day in a law office. Then we focused on grammar, using reported speech to relay messages accurately and question intonation to sound polite and confident, even when you're asking something on the spot. You also picked up some real legal idioms, phrases like "get back to you," "for the record," and "touch base," all tools for sounding natural and professional. Most importantly, we practice how to manage legal phone calls, taking messages, responding clearly, following up, and keeping calm and courteous under pressure. Great work today. Your legal English communication is getting stronger with every class. See you in the next one. How do experienced lawyers build trust with clients? In this advanced legal English class, we'll focus on high-level communication strategies like active listening, confidentiality, and building rapport. You'll also learn to use mixed conditionals and discourse markers to speak with clarity, empathy, and authority in client conversations. Perfect for legal professionals who want to master the language of trust. This is part of our full legal English course for lawyers and legal professionals. If you want access to all the lessons, plus community support and practice, join us in our Skool community. The link is in the description. Here's what we'll focus on in today's advanced class. First, you'll learn essential vocabulary for creating trust, words like rapport, confidentiality, and active listening. Next, we'll practice using discourse markers like frankly, to be honest, and as I was saying. These help you sound natural and structured in client meetings. We'll also work on mixed conditionals so you can speak clearly about hypothetical situations. For example, if the client had signed the contract, we wouldn't be in court. And finally, we'll apply everything in professional conversations where trust and empathy really matter. Let's begin. When you hear the phrase building rapport with the client, what comes to mind? Maybe you think about trust, that feeling when a client feels safe, understood, and respected. Or you think about connection, being able to speak clearly, listen actively, and make the other person feel heard. In legal practice, rapport isn't just about being friendly. It's about building a strong professional relationship that makes communication easier and outcomes better. Here are some ideas to get you thinking: trust, understanding, empathy, clear tone, body language, and professionalism. Now, let me share a few thoughts. To build trust, a lawyer should, I'd say, listen carefully, speak honestly, and show that they care about the client's goals. One thing that makes a client feel safe is being clear and calm, even when the topic is emotional and complex. And the best way to build rapport in English is, I would say, use polite, respectful language, repeat what you understand, and speak with empathy. Think about your own experience. What helps you trust someone? Let's use those ideas as we dive into today's lesson. Let's start with an essential word, rapport. Rapport is that natural connection you feel with someone when the communication flows easily, especially in professional relationships like lawyer and client. Imagine this: a new client walks into your office. They're nervous, maybe even angry. You listen calmly, make eye contact, and say, "I understand this is difficult." As the conversation continues, the client relaxes. They begin to trust you. That feeling, that bridge between you, that's rapport. It's not about being overly friendly, it's about being human, professional, and attentive. You build rapport by listening, showing understanding, and speaking clearly and respectfully. In legal work, rapport is the foundation of trust, and trust leads to better outcomes. Next, let's talk about a core principle of legal ethics: confidentiality. In law, confidentiality means that anything your client shares with you, whether it's in writing, spoken, or implied, must be kept private. This is not just a moral expectation, it's a legal duty. Imagine you're meeting with a client for the first time. They share sensitive details about a business deal or a family dispute. Even if they don't hire you, that information is protected. You're not allowed to discuss it with colleagues, mention it to friends, or use it to benefit another client. Confidentiality is what makes clients feel safe speaking to you. It creates space for honest communication. In many jurisdictions, breaking this duty can lead to disciplinary action, disbarment, or even lawsuits. So when you say, "As your lawyer, I can assure you that this will remain confidential," you're not just being polite, you're invoking a professional obligation and reinforcing trust. Now, let's look at a powerful communication skill: active listening. This goes beyond just hearing your client's words. Active listening means you're present, focused, and engaged. You're not thinking about what to say next. You're paying close attention to what they're saying now. Imagine this: you're in a client meeting. The client explains their legal issue. You nod, you make eye contact, maybe you paraphrase or say, "Let me make sure I understand." You're saying the company didn't follow through on the payment terms, correct? That's active listening in action. You show that you're listening. You check for understanding. You reflect the speaker's concerns back to them. This does two things: it builds rapport. Your client feels heard and respected. It reduces misunderstandings, which is essential in legal work, where small details matter. Active listening builds trust faster than any legal term or polished phrase. It's not just about being a good communicator, it's about being a better lawyer. Let's talk about the word transparency. In law, transparency means being open and honest, especially about fees, timelines, risks, and outcomes. Imagine this: a lawyer tells a client, "This case may take up to 6 months, and if we lose, there may be additional costs. Here's a full breakdown." That's transparency. It builds trust because the client knows what to expect. There are no hidden surprises. The relationship starts with honesty. Being transparent doesn't mean telling the client everything you know. It means telling them everything they need to make informed decisions. Boundaries, an essential word in professional communication. Boundaries are the invisible lines we set to stay professional. Think of things like when and how clients can contact you, what you can or cannot guarantee. When a conversation becomes emotional or personal, let's say a client starts messaging you on WhatsApp at midnight, asking for urgent updates. If you respond every time, that boundary disappears. Instead, you might say, "For any legal updates, please email me during working hours. I want to give your case full attention when I'm in the office." Boundaries protect your time, energy, and professionalism, while still showing care and respect. Finally, let's learn reassurance, one of the most human parts of legal communication. Clients come to lawyers stressed afraid, or confused. Reassurance means giving them confidence, not fake promises, but real, calm explanations. For example, a client says, "I'm worried I'll lose everything in the divorce." You reply, "That's completely understandable. But let's walk through your rights and what the law says. You're not alone. We'll take this step by step." That's reassurance. You acknowledge their fear. You explain clearly and calmly. You make them feel supported. It's one of the key ways we build trust in emotionally difficult legal situations. Let's start with a vocabulary challenge. Imagine this. A new client walks into a firm. She's nervous. She's never hired a lawyer before. The lawyer explains the case clearly, including the fees, the steps involved, and even some of the possible risks. She leaves feeling informed, not surprised, not confused. What word describes that clear, honest communication? Transparency. Transparency is about openness, sharing the truth, even when it's uncomfortable. It builds trust because clients know they're not being misled. Now, think of this situation. A client is stressed. They might lose their job. They don't understand the legal process and feel overwhelmed. The lawyer listens carefully, then says, "It's a tough situation, but we'll go through each step together. I've handled many similar cases, and you're not alone." What do we call that calm, comforting response? Reassurance. Reassurance means giving emotional support, not just legal facts. It helps the client feel safe and builds confidence in both you and the process. Here's another scenario. A client calls and starts sending WhatsApp messages at midnight. The lawyer gently responds the next morning. He says, "I'd love to help. Please contact me during business hours. That way, I can give your case the attention it deserves." What do we call these limits, these professional limits? Boundaries. Boundaries are necessary in any lawyer-client relationship. They help protect your time, reduce emotional burnout, and create a respectful, clear structure for communication. Let's look at a new group of words called discourse markers. These are words we use to connect ideas in conversation or writing, especially in professional legal communication. For example, however shows contrast. It's like saying but in a formal way. Therefore shows result or consequence. In fact, adds emphasis or correction. Although introduces something surprising or opposite to what we expect. You'll hear these in client meetings, contracts, legal emails, and they help you sound logical, persuasive, and clear. Let's say your client believes a lawsuit will be quick and simple. You've reviewed the case and want to gently explain that it may take time. "We hope this case would resolve quickly, blank. There are several legal complications we must address first." Now, think. Which word shows polite contrast? The answer is however. However is a formal and respectful way to say but. Lawyers use it to introduce something that contrasts or disagrees with what was just said, without sounding rude or emotional. Here's a real legal scenario. A company failed to deliver goods on time. The lawyer explains, "The supplier missed 2 deadlines and didn't respond to our emails. Blank, we will file a claim for breach of contract." Which word shows that filing the claim is the logical result? Therefore. Therefore connects facts to their consequences. It helps you sound clear and logical when explaining decisions or legal steps. Imagine your client says, "I don't think the employer broke the law." You respond, blank, "The company failed to provide your severance pay or issue proper notice." You're gently correcting their idea. So, which word fits? In fact. In fact is used to add a surprising or important detail. It often corrects or reinforces the truth in a respectful way. Useful when clarifying legal facts. Imagine this. A client followed all your advice and submitted their documents on time. Still, the court rejected their application. You explain, blank, the documents were complete and submitted early. The court rejected the request. What word introduces this unexpected twist? Although. Although shows contrast, especially when something unexpected happens. It's helpful when explaining outcomes that don't match expectations. Let's review everything with a real example. You're writing to a client about a hearing. You want to sound clear, logical, and confident. And these 4 discourse markers help you do that. First, the judge reviewed our arguments carefully. However, she requested more documentation. You're showing respectful contrast. Things didn't go exactly as planned. Then, we submitted all required evidence. In fact, we included 2 extra witness statements. Here, you emphasize your effort and correct a possible assumption. Next, although the opposing party objected, the judge accepted our timeline. This shows something unexpected happened and still turned out well. Finally, therefore, we expect the final decision next month. This connects the events to a clear, logical result. These 4 small words, however, in fact, although, and therefore, can make your legal communication powerful, professional, and persuasive. Let's talk about mixed conditionals. These are perfect for legal reasoning. In legal English, we often describe how something in the past led to a current problem, or how a better condition now could have changed something in the past. For example, if the client had followed our advice, she wouldn't be facing a lawsuit. This tells us the advice was in the past, and now there are legal consequences. That's past cause, present effect. Another example, if the clause were clearer, the contract would have avoided confusion. This one describes a present problem, unclear wording, and a past mistake that happened because of it. We call these mixed because the 2 parts come from different times, but they always connect logically. Let's look at each type more closely. Let's look at this powerful structure in legal English. Mixed conditionals that show how a past event affects the present. We use this when something didn't happen in the past and that causes a problem or result now. Let's break it down with 2 examples. Number 1, if the lawyer had filed the claim earlier, the case would be active today. Here's the story. Imagine a lawyer missing the deadline to file a legal claim. That happened in the past. Because of that mistake, the court closed the case, and now, today, the client has no active case. This sentence helps us express both parts. The past cause had filed the claim earlier, but didn't, and the present result, that the case would be active today, but it's not. This is very common in legal settings, explaining consequences of missed actions. Example number 2. If they had reviewed the evidence, they would know what happened. Here's another legal situation. Let's say a legal team went to court without checking the full case file. That happened in the past. Now, in the present, they are confused about the facts of the case. This sentence lets us express that connection. Past failure had reviewed the evidence, but didn't. Current problem, they would know what happened, but they don't. This mixed conditional helps lawyers, judges, and clients talk about missed actions that created present difficulties, a crucial skill in legal reasoning and client communication. Let's look at another important mixed conditional in legal English, one that shows how something that is true now caused a problem in the past. This structure is useful when reviewing contracts or explaining mistakes that already happened. Let's break it down with some examples. Example 1. If this clause were clearer, the dispute would have ended sooner. Here's the situation. There's a contract clause that is confusing, and it's still unclear today. Because of that confusion, the dispute happened in the past, and it took a long time to resolve. The sentence explains the present condition. This clause were clear, but it's not. And the past result. The dispute would have ended sooner, but it didn't. This type of sentence is useful in contract review, where a lawyer explains how a current problem, like unclear wording, created a delay or issue in the past. Example 2. If the contract included penalties, the client would have paid on time. Let's say a client paid their invoice late, and the business wants to know why. The lawyer reads the contract and realizes there were no penalty clauses. That's the present situation. Because the contract still doesn't include penalties, we now understand why the client was late in the past. So again, the present condition, which is the contract included penalties, but it doesn't, and the past result, the client would have paid on time, but didn't. This structure is excellent for legal analysis when you're explaining how a flaw or omission in a current document led to a past legal consequence. When you're speaking with a client, it's not always about talking more. It's about listening carefully and knowing when to get to the heart of the matter. This means focusing on what really matters in the case, the key legal problem or personal concern behind the client's words. For example, during the meeting, the lawyer gently got to the heart of the matter. The client was afraid of losing custody. In legal conversations, getting to the heart of the matter shows empathy and builds trust. Sometimes a client won't say exactly what they're feeling. They may sound fine, but their tone or silence says something else. As a lawyer, you often need to read between the lines. This means noticing what's not being said, the emotions, concerns, or unspoken fears. An example, the client said everything was okay, but the lawyer read between the lines and sensed hesitation about signing the agreement. Being able to read between the lines helps you respond with care and build deeper rapport. Legal meetings can be intimidating for clients. A good lawyer knows how to put someone at ease, to help them feel calm and safe. You might do this by using a warm tone, offering reassurance, or explaining things clearly. For example, the attorney put the nervous client at ease by starting with a friendly question and a smile. This small moment builds big trust. Clients want to feel informed and involved. A lawyer who keeps someone in the loop, sends updates, explains next steps, and checks in often. This idiom means making sure someone knows what's happening. It builds transparency, which builds trust. An example, the firm kept the client in the loop throughout the trial preparation, which made her feel supported. Using this idiom shows you value clear, ongoing communication. Now, I want to finish this up with telling you a story. I'm telling you a story about a missed opportunity to build trust. A new client came into the office, visibly stressed. The lawyer welcomed him and did her best to build rapport. She used active listening, repeated his concerns, and showed empathy. In fact, she took notes and asked thoughtful follow-up questions. However, she forgot to explain the rule of confidentiality, something that's essential in first meetings. Because of that, the client held back on key details. If she had explained confidentiality at the beginning, the client would feel more comfortable sharing now. That's a missed chance to build deeper trust. Later in the conversation, she said, "Although your case is complicated, we do have strong legal arguments." And she concluded, "Therefore, I recommend taking action before deadlines become a problem." Still, the client didn't seem fully convinced. If the lawyer were more tuned in to emotional cues, she would have earned the client's trust that day. He left the meeting with doubts. and eventually hired another firm. A senior partner told her, "You have got to read between the lines. Clients don't always say what they need. You have to sense it." Next time, she'll prepare better, hoping to get ahead of the problem before it becomes a missed opportunity again. Let's review what you learned today. First, we explored how to build rapport and trust with legal clients using strong communication skills like active listening. We talked about confidentiality, how explaining it clearly can help clients open up. You practice mixed conditionals, which help you express past mistakes and present consequences, a powerful tool for lawyers. We also learned how to use discourse markers like however, therefore, and although to create more fluent and persuasive communication. And finally, we added some natural, high level idioms like read between the lines and get ahead of the problem. Phrases that make your English sound confident and advanced. Keep practicing, and you'll build not just trust, but mastery. Even at an advanced level, legal English mistakes can cost you. Join our Skool group for expert lessons, live sessions, and practical support, and gain confidence communicating, drafting, and negotiating. The link is in the description. How do top lawyers persuade without sounding aggressive, uncertain, or vague? In this advanced legal English class, we'll focus on how to structure legal arguments clearly, respectfully, and strategically. You'll learn high-impact vocabulary for persuasion, along with advanced grammar tools like inversion and formal register, perfect for legal professionals who want to frame arguments with precision and professionalism. This is part of our full legal English course for lawyers and legal professionals. If you want access to all the lessons plus community support and practice, join us in our community. The link is in the description. Today's lesson is about strategic language. Whether you're defending a client or advising one, how you frame your argument matters just as much as the content. We'll explore advanced tools like inversion and formal register that help you sound more credible, authoritative, and persuasive. You'll also build vocabulary for legal reasoning, helping you present points clearly, logically, and respectfully in professional conversations. What actually makes a legal argument persuasive? It's more than just confidence or legal knowledge. A persuasive legal argument is built on logic and legal reasoning, but it's also delivered with control, precision, and respect. You need emotional control to avoid sounding aggressive and a formal, respectful tone to show professionalism, especially in high-stakes negotiations or courtroom settings. You're not just stating your case, you're guiding your audience toward your client's position. Effective legal speakers anticipate counter-arguments and address them head-on. They use clear structure and transitions to organize their reasoning. They speak with authority, back claims by presenting evidence, and never lose sight of the client's objectives. Let's warm up by completing some of the thoughts together. One element of persuasive legal language is anticipating counterarguments before the opposing side raises them. This allows you to stay in control of the conversation and build credibility. If your tone is too emotional, your legal reasoning may be undermined, and your argument may come across as unprofessional. Remember, persuasive doesn't mean passionate, it means precise. Strong arguments usually include structured logic, clear transitions, and evidence tied directly to the client's goals. We'll now explore the specific language and grammar structures that help you to do this naturally in English. Let's get started. Let's start with vocabulary. And first up is persuasive language. Persuasive language refers to the strategic use of words and tone to guide someone's thinking. In legal conversations, this doesn't mean being manipulative. It means helping clients or opposing counsel see the logic in your position. Take this example. We strongly recommend this course of action based on the facts and legal precedent. This phrase builds trust. It shows you're not just giving an opinion, you're grounding your advice in the law. Imagine you're advising a business client considering two settlement options. You don't say option B is better. You say we strongly recommend option B as it aligns with established precedent and minimizes long-term exposure. That's persuasive and professional. Throughout this lesson, you'll learn how to choose words that are clear, calm, and convincing, even under pressure. Now, let's talk about legal reasoning, the backbone of persuasive legal communication. Legal reasoning means connecting the dots between the law and the facts. It's not just about stating what happened, it's about explaining why that matters, using the legal framework to guide the listener to a conclusion. For example, given the breach and the lack of notice, we believe liability is likely. This isn't emotional, it's calm, structured, and backed by law. Imagine a client asks if they have grounds to terminate a contract. Instead of a vague answer, you walk them through it step by step. The other party failed to deliver on time, which constitutes a material breach. Based on Section 10 of the agreement, that breach gives us the right to terminate. This kind of response builds confidence and clarity. Your legal reasoning shows not just what you recommend, but why. In any legal discussion, you can't just build your own case. You also need to anticipate the other sides. That's where the concept of a counterargument comes in. A counterargument is a possible objection or opposing view. Skilled lawyers think two steps ahead. They identify these challenges and prepare responses in advance. Let's say you're advising a client who wants to enforce a contract clause. You might say, one possible counterargument is that the clause was never enforced in previous cases. However, we have evidence that both parties acknowledged it in writing last year. Here, you're not just reacting, you're framing the conversation proactively, showing the client that you've considered all angles, and that's what builds trust and credibility in legal communication. In courtroom advocacy or negotiations, this approach is vital. You present your position, address the counterargument, and then explain why your view remains the stronger one. Let's talk about a foundational concept in legal reasoning, the burden of proof. This phrase, burden of proof, refers to who must prove what in a legal dispute. In civil cases, it is usually the plaintiff who carries the burden. They must provide enough evidence to convince the court that their claim is valid. For example, imagine a client wants to sue for breach of contract. You might say, the burden of proof lies with the plaintiff to establish that the contract was breached. That means your client needs documentation, witness statements, or other credible evidence. Understanding this concept shapes your legal strategy. What evidence do you need to gather? How strong is your case based on what you can prove, not just what you believe? Communicating this clearly to clients helps them manage expectations, understand legal risks, and make better decisions about proceeding. In legal conversations, especially in adversarial contexts, you often need to disagree without sounding aggressive. That's where the word rebuttal becomes useful. A rebuttal is a strategic response, not just a disagreement, but a well-reasoned reply that undermines the other party's argument using facts, logic, and/or legal precedent. For example, Suppose opposing counsel claims your client breached a contract. You might say, her rebuttal emphasized that the client had acted within the terms of the agreement. This isn't just denying the claim, it's presenting a counter narrative grounded in evidence and framed with precision. Effective rebuttals require emotional control so you don't sound defensive, a formal tone, even when pointing out flaws, and a structure. Acknowledge the point, then redirect with logic and legal reasoning. Mastering rebuttals means you can stand your ground while maintaining professionalism, a key skill in both litigation and negotiation. In legal communication, what you say matters, but how you say it often matters more. This is the power of framing. Framing refers to the strategic presentation of facts, questions, or arguments to guide how others interpret a situation. You're not changing the facts, you're changing how the facts are seen. Let's say your client took a risky business decision. You could present it as reckless, or you could reframe it as the attorney's framing of the facts made the client's position seem both reasonable and compelling. She didn't lie. She highlighted motivations, context, and the client's diligence, all to lead the listener toward a more favorable understanding. Framing is about shaping perception without distorting truth, emphasizing strengths while downplaying weaknesses, aligning your argument with client objectives, whether you're talking to a judge, opposing counsel, or even the nervous client. Framing helps you stay persuasive, composed, and in control of the conversation. Imagine this. You're advising a client in a workplace discrimination case. The opposing side describes it as miscommunication, but you open the discussion by stating, this is a case about consistent bias and unequal treatment over time. You've shifted the narrative from a minor issue to a systematic problem. What do we call that technique when we strategically shape how a case is viewed? The answer is framing. Framing is about shaping perception. A well-framed argument puts your client's story front and center, not just the facts, but how those facts feel and function within the legal context. In a real estate dispute, the seller claims your client delayed the payment, breaching the contract, but you produce emails and bank records showing that the seller failed to provide the correct wire instructions, making timely payment impossible. You're not just defending, you're dismantling their claim. What is this kind of pointed legal response called? A rebuttal. A rebuttal doesn't just deny, it responds. It uses facts and logic to flip the weight of the argument and show the other side's claim doesn't hold up. You're in mediation for a breach of contract case. The plaintiff says your client never delivered services, but they haven't shown invoices, communication, or any attempt to follow up. Your response is simple. They made the allegation. Now they must prove it. What legal concept are you referring to? The answer is burden of proof. The burden of proof lies with the party making the claim. In civil cases, this usually means showing evidence that supports their version of the story. It's a cornerstone of fairness in legal process. In a zoning appeal, the opposing lawyer argues that approving your client's project would increase traffic congestion. You respond with studies showing that the development actually reduces pressure on surrounding roads due to planned infrastructure upgrades. You didn't ignore their point, you met it head on. What is this strategy called? A counter-argument. And a counter-argument is a critical part of strong advocacy, not just asserting your case, but addressing the weaknesses in the other side's logic before they become roadblocks. In a visa denial case, you don't just say the officer made a mistake. You cite the exact section of the immigration code, interpret how it's been applied in prior cases, and explain why the evidence submitted meets the standard. You're not improvising, you're constructing logic. What's the name for this kind of structured analysis? It is legal reasoning. And legal reasoning is the disciplined logic that holds a legal argument together, applying precedent, statutes, and facts to produce persuasive, defendable conclusions. A client wants to sue a former business partner, but litigation would be costly and public. You craft an email that doesn't threaten, but suggests. Given the uncertainty of court outcomes and the costs involved, we believe an amicable settlement serves both sides. You're nudging, not pushing. What kind of language are you using? You are using persuasive language. And persuasive language blends professionalism with subtle influence. It's how legal professionals guide conversations, not with force, but with strategy and diplomacy. In legal conversations, especially in formal or persuasive situations, how you emphasize a point can completely change how it lands. That's where inversion comes in. It's when you flip the sentence order to give a statement more weight or formality. Compare these two. This issue has never been raised before. Never has the issue been raised before. The second version sounds more emphatic, more authoritative. That's exactly the tone you often need in courtrooms, hearings, or negotiations. Here are a few more legal examples. At no point did the client receive proper notice. Only after reviewing the records did we discover the breach. Under no circumstances should this clause be interpreted loosely. We'll practice how to use inversion in structured arguments shortly, but remember, inversion equals control, formality, and impact. Let's practice how inversion helps us sound more precise and persuasive in legal contexts. Below are 3 typical legal statements. Your job is to rephrase them using inversion for extra emphasis. Let's try the first one. The client was never informed of the change. 2. Never was the client informed of the change. Going on to the next one. We only discovered the error after the settlement. Only after the settlement did we discover the error. They didn't consider the plaintiff's rebuttal at any point. At no point did they consider the plaintiff's rebuttal. In each case, inversion adds weight. It's no longer a neutral observation. It becomes a pointed, authoritative claim. And that's often what legal advocacy requires. Now, let's turn to formal register, a key element of persuasive legal English. In courtroom or negotiation settings, you're not just speaking politely. You're using a strategic tone that commands respect, avoids confrontation, and builds credibility. Take these examples. Instead of saying, you have to prove it, a lawyer should say, the burden of proof lies with the claimant. It's formal, neutral, and legally precise. Rather than, that's not true, you might hear, this assertion is not supported by the evidence. This distances the speaker from emotional reactions and focuses on fact. Instead of saying, we think the contract is unfair, you could say, it is respectfully submitted that the contract is unconscionable. And instead of saying, we think the contract is unfair, you could say, it is respectfully submitted that the contract is unconscionable. This adds professionalism and legal weight to your position. In this lesson, we'll continue practicing how to shift your language into a persuasive formal register, especially when presenting arguments, rebuttals, or counterpoints. Let's practice turning informal reactions into persuasive formal legal language. Imagine you're in a courtroom or writing a legal opinion. These aren't casual conversations. You want to sound measured, professional, and authoritative. Try transforming these. That's not fair. You could say, this provision appears to be inequitable given the surrounding circumstances. You're wrong about the facts. Try, with respect, the factual basis of that argument appears to be inaccurate. We don't agree with that. Shift it to, our position differs on this matter based on the following legal reasoning. You didn't give us enough evidence. A more formal version is, the evidence provided does not sufficiently support the claim as presented. In real legal conversations, whether in court or during negotiation, this tone shows not only respect, but confidence. Clients, judges, and opposing counsel are far more likely to listen when your language stays calm and elevated, even when the stakes are high. In legal discussions, the phrase call into question is used when someone challenges the reliability, legality, or truth of a claim, fact, or person. Let's say you're advising a client whose signature appears on a disputed contract. The other party insists the signature is real, but your client maintains it was forged. When you present evidence that the document may have been altered, you're not just making a casual comment. You're calling into question the entire validity of the agreement. This idiom is powerful because it implies that something fundamental may be flawed or untrustworthy, a common tactic in both litigation and negotiation. It's a formal but strategic way to shift the burden back onto the opposing party. To draw a clear distinction means to clarify differences that matter, especially when two ideas might otherwise be misunderstood or conflated. Imagine you're representing a company accused of breach of contract. The plaintiff is framing it as intentional deception, but your client misses a deadline due to supply chain issues. In your legal argument, you draw a clear distinction between a willful breach, which could carry punitive damages, and a delay caused by external factors, which may only merit minimal consequences. This idiom shows that you're precise in your reasoning. In legal context, it helps a judge, jury, or opposing counsel see that your position is more reasonable, more nuanced, and ultimately more persuasive. To put forward a compelling case means to present your legal argument in a way that is thorough, logical, and persuasive, with enough weight to convince the decision maker. Picture this. You're representing a whistleblower in an employment dispute. The employer claims there was a justified termination, but you've gathered emails, witness statements, and labor code citations. During the hearing, you put forward a compelling case that your client was dismissed in retaliation for reporting unsafe practices. This phrase emphasizes structure and strength. A compelling case isn't just emotional, it's strategic. You use evidence, legal reasoning, and clarity to show not just what happened, but why it matters under the law. In advanced legal English, this is the language of winning arguments. The phrase "in the interest of justice" is often used in legal settings when an exception or decision is made to protect fairness, even if it bends a strict rule or timeline. Imagine a criminal defense attorney who discovers exonerating video footage the day before trial. Procedurally, it's late, but the lawyer petitions the court to admit it in the interest of justice. The principle is clear. Better to allow the evidence than risk convicting an innocent person. You'll hear this phrase in motions, judicial opinions, and legal arguments. It's a way to signal that fairness, equity, and the integrity of the process outweigh technicalities. Advanced lawyers use this language to appeal not just to the law, but to the higher ideals behind it. To uphold the rule of law means to support and enforce the idea that no one is above the law, not governments, not corporations, not individuals. It's about applying legal standards fairly and consistently, regardless of power or position. Picture this: a constitutional court is reviewing a law passed by a new administration. The law appears popular but violates due process protections. The judge strikes it down, not because it's politically convenient, but because doing so upholds the rule of law. It sends a clear message: laws must follow the Constitution, and justice is not selective. This phrase is powerful when arguing for accountability, constitutional rights, and legal checks and balances. It reminds listeners that justice depends not on who you are, but on the legal framework that governs all. Let's wrap it up with a story with everything we have learned today. Imagine this scene. A senior employment lawyer is speaking before the review panel of a multinational company. Her client, a mid-level manager, was recently terminated after reporting discriminatory practices. The lawyer begins. Rarely have we seen such a clear imbalance in procedural fairness. By using inversion, she commands attention immediately. She frames the issue as a question of systemic bias, not just individual misconduct. Then she draws a clear distinction between her client's performance record and the circumstances that led to the termination. As she speaks, she uses persuasive language, respectful, structured, and formal, emphasizing legal reasoning grounded in the company's own code of ethics. She anticipates the opposing counterargument that the dismissal was based on restructuring, but she is ready. With a calm tone, she puts forward a compelling case, citing internal memos, performance reviews, and timelines that call into question the employer's justification. She shifts the burden. If the company wished to assert this was unrelated to her complaint, then it must provide clear and convincing evidence. The burden of proof lies with them now. By referencing case law and previous internal decisions that rest on strong precedent, she upholds the rule of law while remaining professional. Her final point resonates. In the interest of justice, she says, we ask that you review this termination not as an isolated incident, but as part of a larger pattern. The panel is silent. She's done more than argue, she's persuaded. And that is the power of language when it's strategic, structured, and grounded in law. Let's take a moment to review everything you accomplished in today's advanced legal English class on strategically framing legal arguments. First, you learned high-level vocabulary, words like rebuttal, burden of proof, and persuasive language that help you describe legal thinking clearly and professionally. Then we worked on two key grammar skills: inversion, which adds emphasis and authority to your arguments, and formal register, which helps you speak with the professionalism legal audiences expect. We also introduced idiomatic expressions used in legal argumentation. These include call into question, draw a clear distinction, and in the interest of justice, all of which add persuasive weight to your speech. Most importantly, you put these tools together to present strong, structured legal arguments, the kind that win trust, respect, and results. Want to continue mastering advanced legal English? Join our community for full course access, live workshops, and personalized feedback. The links in the description. We'll see you inside. Not all legal conversations are technical. Some involve pain, loss, fear, or disappointment, and your words can either calm or escalate the situation. Whether you're guiding a client through divorce, delivering bad news about a case, or discussing traumatic events, emotional intelligence is just as important as legal knowledge. In today's lesson, we'll learn how to use professional, precise, and compassionate English when discussing emotionally charged legal issues. Today's lesson focuses on one of the most human and most difficult parts of legal work, talking about painful or sensitive topics. Maybe a client just lost custody. Maybe you have to explain that their claim isn't strong enough to proceed. Maybe you're discussing a traumatic event in a deposition or intake. These are not moments for legal jargon or cold logic. They require empathy, discretion, and clear but careful language. You will learn vocabulary that's professional and respectful. You'll practice softening devices like, it may be difficult to hear this, or you might want to consider. You'll also explore hedging, a way to avoid sounding overly harsh or certain when delivering complex or emotional information. By the end of this lesson, you'll be able to manage these conversations with both legal authority and emotional intelligence in clear, natural, advanced English. Let's begin by reflecting on your experience or what you imagine when handling emotionally charged legal situation. Think of a time when you had to speak with a client who was in pain, angry, disappointed, or overwhelmed. Maybe it was a custody case. Maybe it was delivering bad news about a judgment or a legal option they believed in. Or perhaps it was a client opening up about a traumatic experience, and your role was to listen with care while still providing legal guidance. You might say, one of the hardest conversations I've had was telling a client the appeal was denied. As a lawyer, it's important to stay calm when the client is angry or afraid. Even if the client is upset, we still need to communicate clearly and manage expectations. These are the kinds of conversations that define your professionalism, and your ability to handle them in English is just as critical as your legal knowledge. In legal settings, distress refers to emotional suffering. It can be short term or long lasting, and often appears in cases involving trauma, loss, or injustice. For example, the witness was clearly in distress while describing the events. As a lawyer or mediator, recognizing signs of distress helps you adjust your tone, pace, and language. You might say, if at any point you feel distressed, we can pause. We understand this is a distressing situation and will move carefully. Empathy is not about agreeing, it's about showing that you understand how someone feels. In legal practice, empathy builds trust and strengthens communication. For example, the attorney showed empathy without losing her objectivity. Clients don't just need legal advice, they need to feel heard. You might say, I can see how upsetting this must be. Or, I understand this is difficult. Let's go through it step by step. Discretion means using judgment when discussing sensitive issues. It's especially important in family law, criminal cases, or when trauma is involved. For example, the lawyer handled the client's story with complete discretion. It also refers to respecting confidentiality and knowing when to speak or when to remain silent. You might say, due to the sensitive nature of this matter, I will speak with discretion. Or, let's keep these details confidential for now. Confidentiality is essential in emotionally sensitive matters. When clients reveal painful or personal information, they need to know it's protected. For example, this information is strictly confidential and protected by privilege. You might say, everything discussed in this meeting is confidential. You're free to speak openly. Nothing will be shared without your permission. To deliver bad news professionally means being honest, respectful, and prepared. The phrase is often used when discussing outcomes a client won't want to hear. For example, she had to deliver the news that the appeal had been denied. It's not just what you say, it's how you say it. You might say, I'm afraid I have some difficult news to share, or this may not be what you hoped for, but let's look at your options. Grief shows up in many areas of legal practice: estate law, wrongful death, family law, refugee law, and more. It's important to acknowledge grief without making assumptions. For example, the client was still processing her grief when we began the estate planning. You might say, take your time, there's no rush. We'll go at a pace that feels manageable for you. Trauma affects memory, language, and behavior. When working with clients who have experienced trauma, legal professionals must communicate with care and sensitivity. For example, the witness had difficulty testifying due to past trauma. Understanding trauma informed practice helps protect your client and your case. You might say, if you need a break, we can pause anytime. You are in control of what you share today. Clients may be vulnerable due to age, mental health, immigration status, or past experiences. Recognizing vulnerability helps you choose your language and strategy carefully. For example, children are considered legally vulnerable and require special protection. You might say, we'll make sure your rights are protected throughout the process. If you are feeling overwhelmed, we can pause and go over this again. When delivering emotionally difficult legal information, tone matters. Even when you're being honest, how you say something can deeply affect how it's received. Softening devices help reduce the emotional impact of bad news. They're not about hiding the truth, they're about communicating with respect and care. Let's look at some of these examples. It might be helpful to look at this from a long term perspective, or you may want to consider a settlement given the emotional toll of a trial, or there is a possibility that the outcome may not be in your favor. This may be difficult to hear, but the court rejected the application. Let's look at some of the options going forward. These phrases prepare the listener. They show compassion without weakening the legal message. In emotionally sensitive legal conversations, directness can sometimes come across as harsh, final, or even aggressive, especially when the news is not what the client hoped for. That's where hedging and indirect language come in. These tools help you express uncertainty or caution in a professional, respectful way. Let's examine how this works. For example, it seems that the court was not persuaded by the argument, or there may be some risk involved if we proceed with litigation. From what I understand, the judge tends to favor strict interpretation in these cases, or it's possible the court will request further documentation. Last one, we can't be completely certain, but this may not be the strongest strategy. These phrases allow you to communicate risk and reality while preserving trust and softening the emotional impact. They are especially useful when you're not giving advice yet, just managing expectations in early or difficult conversations. Now, let's apply what we have learned. We are going to take these direct and potentially harsh legal statements and rephrase them using the softening and hedging techniques we just reviewed. Here's how you might rephrase each one. Your case has no chance. There may be limited legal grounds to move forward in this particular case. You are clearly at fault. 2. It appears that the facts may suggest some liability on your side. Or, this won't work in your favor. 2. It's possible this argument may not be viewed as strong by the court. The court rejected your argument. The court seemed unconvinced by that particular point. Or, you didn't follow the process. There may have been a step that was overlooked, which could affect the outcome. This type of language reduces emotional tension, maintains professional tone, and helps preserve the client relationship, even in difficult situations. Remember, you're still being clear, but you're also being kind. Break the news. This phrase is commonly used in both legal and medical professions when a professional must inform someone of difficult or painful news. For example, I had to break the news their asylum application had been denied. You might say, before we discuss next steps, I need to break some difficult news. We'll go through it together after I break the news. This phrase prepares the listener for something serious and sets a compassionate tone for the conversation that follows. Manage expectations. This phrase is central to the ethical legal communication. Clients often come in with assumptions or hopes that don't align with legal reality. For example, part of the lawyer's job is to manage the client's expectations about trial outcomes. You might say, let me manage expectations before we proceed. This could take several months. Or, I want to be clear about what's possible so we can manage expectations early on. This is a professional, respectful way to prevent disappointment while still being honest. Act in the client's best interest. In emotional cases, clients may push for outcomes that are unrealistic or even harmful to themselves. Your role is not just to deliver news, but to protect them legally and personally. For example, even when the news is hard to hear, we have to act in the client's best interest. You might say, my advice may be difficult to accept, but it's based on your best interest. Or, we will only take steps that serve your long term best interest. This phrase reinforces your professional responsibility, especially in highly emotional situations. Respect the client's wishes. When clients are grieving, angry, or overwhelmed, they may still have strong views on how they want to proceed. Part of professional legal communication is recognizing their autonomy, even when you offer a different view. For example, the lawyer must respect the client's wishes, even when disagreeing with their approach. You might say, I'll explain the risks, but I will respect your decision. As long as you're fully informed, I will respect your wishes on how to proceed. This phrase shows balance. The client leads the decision, but you guide the process. Let's wrap it up with a story. You're meeting with the client whose immigration petition was denied. She's been waiting for over a year and believed the outcome would be positive. She's under emotional strain, and this conversation must be handled with care. You begin. I'd like to start by saying that everything we discuss here remains completely confidential. I understand how much this matter means to you. Then, with empathy and caution, you prepare to break the news. This may be difficult to hear, but I want to let you know that the decision from the immigration court was not in your favor. You pause, observe her reaction, and continue gently. I know this is distressing, and I want to go through it step by step so you understand what happened and what options may still be available. You use hedging and softening to keep the tone respectful and calm. You say, it seems that the court focused heavily on documentation gaps. There may have been some misunderstandings in how certain evidence was interpreted. As emotions rise, you manage expectations. You say, it's possible that an appeal may not succeed, but we will look closely at the decision and discuss what's realistic. My role is to act in your best interest. She insists she wants to fight the decision. You reply, I fully respect your wishes. Let's take a look at what legal avenues still exist and see what's feasible from a strategic standpoint. You close the meeting with clarity and reassurance. I'm here to support you through this, not just legally, but professionally. And we'll take the next steps together. This is how legal professionals communicate hard truths with professionalism, tact, and humanity, especially in the moments that matter most. Let's review what we focused on today. You learned how to speak professionally in high-stress legal situations, moments when your clients are afraid, grieving, or disappointed. We covered advanced vocabulary to describe emotional and sensitive issues, and practice using softening and hedging strategies to reduce the emotional impact of legal communication. You also learned 4 key phrases used in law and legal practice when dealing with emotionally complex matters, from breaking the news to managing expectations and respecting client autonomy. Finally, we brought it all together in a storytelling simulation, showing how to speak clearly, respectfully, and compassionately, even when the outcome isn't what the client hoped for. This is what true legal communication mastery looks like, not just technical accuracy, but emotional intelligence and language precision. Every legal system has its own language, precise, complex, and full of meaning. To think like a lawyer, you must first speak like one. In this lesson, we'll uncover 20 foundational terms that every lawyer in any country or legal tradition must understand. These words appear in constitutions, contracts, and courtrooms worldwide. They are the building blocks of justice. By the end, you'll not only know what they mean, but also see how they come alive in real world situations. If you want to move beyond definitions and use this language confidently in meetings, filings, or client interviews, join our Legal English community. We hold live sessions every week with lawyers, judges, and law students across the world. Inside, you'll learn to communicate precisely, argue persuasively, and understand authentic legal materials. So, as you watch this lesson, imagine applying each word in your professional life. And when you're ready to take the next step, come practice with us. The word law is the cornerstone of civilization. It is a structured collection of rules designed to protect people, define responsibilities, and resolve disputes. Let's read the example. The law protects citizens' rights and maintains order. Think about how law functions every day, from the traffic rules that keep roads safe to the criminal codes that punish wrongdoing. Without law, there would be chaos, no predictable way to settle conflicts or protect the weak. Every government enacts laws that reflect its values. Some prioritize equality, others economic freedom. But everywhere, the law stands as the line between order and disorder, guiding how societies live together peacefully. A legal system is like the architecture of justice, the framework that holds everything together. It includes the courts, judges, lawyers, and laws that define how justice is done. In our example, each country has its own legal system and procedures. Think of the difference between France and the United States. France relies on detailed legal codes. The U.S. depends heavily on judicial decisions. Even though the structures differ, each system aims for the same goal: fairness under the rule of law. Understanding a nation's legal system allows lawyers to predict outcomes, navigate procedures, and communicate effectively across borders. Legislation is the product of democracy, the written rules created by elected representatives. It transforms public debate into binding law. The example says, new environmental legislation was approved by Congress. Picture a public outcry over polluted rivers. Lawmakers study the issue, draft a bill, debate it, and finally pass new legislation requiring industries to reduce waste. That statute now carries the full force of law. Legislation is dynamic. It changes as societies evolve. Lawyers must read it carefully, interpret it accurately, and ensure it serves justice rather than politics. A statute is legislation in its most concrete form, a written rule that everyone must follow. It's precise, public, and enforceable. Our example reads, the statute requires companies to report annual profits. Imagine a government wanting transparency in the corporate world. Parliament enacts a statute compelling all businesses to disclose profits. From that moment, compliance becomes a legal duty. Statutes provide clarity and certainty. You can open a law book and find the exact rule, but interpretation still matters because one word in a statute can decide a lawsuit. Regulations turn broad laws into everyday practice. When legislators pass a statute, government agencies issue regulations explaining how it works. Our example says, financial regulations protect consumers and ensure fair markets. Picture a new banking law requiring fair lending. The financial authority writes detailed regulations on how banks must evaluate credit, disclose fees, and prevent fraud. These rules guide professionals and protect the public. Regulations are the practical side of the law, where policy meets daily life. Jurisdiction is about power, the power to decide a case. It defines where and over whom a court or government can act. The example: the court had no jurisdiction over foreign companies. Imagine a Costa Rican judge trying to decide a dispute between two U.S. corporations that have no connection to Costa Rica. That court lacks jurisdiction. It simply doesn't have legal authority. Knowing jurisdiction prevents wasted time and invalid judgments. It's the first question every good lawyer asks. Does this court have the right to hear my case? Precedent is the legal memory of the system. It ensures consistency by requiring courts to follow earlier decisions in similar situations. Let's take the example. Judges often rely on precedent when interpreting the law. Suppose a court ruled years ago that online contracts are legally binding. Today, a similar dispute arises. A judge looks to that earlier precedent for guidance. This process keeps the law stable while allowing it to evolve. Precedent is what makes common law systems predictable. Lawyers can look backward to move forward. Case law is law created not by politicians, but by judges. Each time a court explains its reasoning, that judgment becomes part of a growing body of case law. Our example says, case law helps lawyers predict how courts might rule. Imagine a lawyer researching a negligence claim. She studies hundreds of past decisions where similar injuries occurred. By analyzing the reasoning behind those rulings, she can predict how today's court might decide. Case law connects legal theory with human stories, turning decisions into guidance for the future. In civil law systems, everything starts with the written code. Judges don't make law, they apply it. Let's read the example. Most European and Latin American countries follow the civil law tradition. Imagine a judge in Argentina. Instead of searching for past rulings, she opens the civil code to the exact article that applies. That article, drafted by legislators, covers nearly every possible scenario. Civil law values structure, logic, and predictability. It's like a rule book for justice: clear, comprehensive, and systematic. Common law, in contrast, grows from experience. Its roots go back to medieval England, where judges developed rules by deciding cases one at a time. Our example says, the United States and the United Kingdom follow the common law system. In these systems, judges have a great influence because their interpretations become law for future courts. It's flexible. The law can adapt quickly to new realities, such as digital privacy or artificial intelligence. Common law breathes through precedent,
evolving with society's needs. The defendant is the person standing at the center of legal action, defending themselves against an accusation. In our example, the defendant pleaded not guilty to all charges. Picture a courtroom. The judge presides, the prosecutor presents evidence, and the defendant listens carefully while their counsel argues their innocence. In civil cases, the defendant may be a company sued for breach of contract. Regardless of the type of case, the defendant enjoys fundamental rights to be heard, to present evidence, and to receive a fair judgment. Their role embodies the principle that everyone is presumed innocent until proven guilty. The plaintiff is the one who starts the legal action, the person or organization that brings a claim before the court seeking justice or compensation. In our example, the plaintiff claimed damages for breach of contract. Imagine a small business that paid a supplier for goods that never arrived. After months of unanswered calls, the owner decides to act. She becomes the plaintiff by filing a lawsuit demanding repayment and damages. In civil law systems, the plaintiff is often called the claimant. Regardless of the term, this role represents the voice that says a wrong was done and the law must fix it. The plaintiff sets the entire judicial process in motion. In the courtroom, counsel is more than just a lawyer. It's the professional entrusted with defending someone's rights. Let's look at the example. The defense counsel presented strong evidence in court. Imagine a corporate dispute where millions are at stake. The company's counsel must build a clear argument, question witnesses, and interpret the law with precision. The word can refer to one lawyer or an entire legal team, defense counsel, plaintiff's counsel, or general counsel for a corporation. The role demands not only legal expertise, but also ethics and judgment. Good counsel doesn't simply win cases, they guide clients through complexity toward lawful solutions. The judge is the guardian of fairness, the person who listens to both sides, interprets the law, and ensures justice is done. Our example says the judge ruled in favor of the plaintiff. Picture a courtroom filled with arguments and tension. The judge's role is to stay neutral, weigh the evidence, and apply the law with reason and humanity. In some systems, judges also sentence offenders. In others, they guide juries to reach decisions. A good judge balances compassion with discipline, authority with humility. Every courtroom depends on their impartiality, because justice means nothing unless the person deciding is truly fair. A court is more than a building. It's the place where the power of law comes to life. Our example says the case was brought before the Supreme Court. Courts can be local or international, civil or criminal, but they all share one mission: to resolve disputes according to law. Imagine two neighbors fighting over a property line, or a multinational company accused of environmental harm. Both rely on the court's authority to settle the matter peacefully. Courts symbolize justice in action. They transform personal conflict into structured resolution, replacing revenge with reason. A judgment is the final word, the formal decision that closes a case and determines who wins and who loses. Let's read the example. The court issued its final judgment after the trial. Imagine months of hearings, witnesses, and evidence. When the judge finally delivers judgment, it becomes binding law for those parties. In civil cases, a judgment might order payment or performance. In criminal cases, it may determine guilt or innocence. But every judgment also sets a precedent, a message to society about what justice means in practice. It is the moment when theory becomes reality and justice takes written form. Evidence is the lifeblood of every trial. It's what turns arguments into proof. Our example reads, "The lawyer presented new evidence that changed the outcome." Imagine a case hinging on a single fingerprint, a missing email, or a witness's memory. That one piece of evidence can completely transform the story. Evidence comes in many forms: documents, photographs, physical objects, or testimony. For lawyers, understanding how to gather, present, and challenge evidence is an art. In the end, justice doesn't depend on passion or eloquence. It depends on facts that can be proven beyond doubt. Rights are what give law its moral power. They define what individuals may do and what others, including the state, must respect. Our example says citizens have the right to a fair trial. Picture an accused person standing before a court. Their right to be heard, to have a lawyer, and to know the charges against them. These are fundamental protections. Rights can be civil, political, or economic, and they differ across nations, but their purpose is universal: to protect human dignity. When rights are upheld, law serves humanity. When they are ignored, law becomes oppression. An obligation is a legal bond, a duty created by law, contract, or moral commitment. Let's take the example. The contract creates an obligation to deliver goods on time. Imagine a company that agrees to supply medical equipment. That promise becomes a binding obligation. If they fail to deliver, they breach the contract and may face damages. Obligations are the backbone of commerce and trust. They keep economies functioning and ensure reliability in legal relationships. To fulfill one's obligations is not only a legal requirement, it's a measure of integrity. Liability is about accountability, the legal consequence of one's actions. Our example says the company accepted liability for the damages caused. Imagine a factory that pollutes a river, harming local communities. Once the court determines fault, the company becomes legally liable for the cleanup and compensation. Liability can arise from contracts, negligence, or even strict legal duties. For lawyers, identifying who bears liability is at the core of every case. It's what transforms harm into justice, ensuring that responsibility follows wrongdoing. In every society, the law operates within a structured legal system that maintains order and protects rights. Legislation establishes the framework, statutes define obligations, and regulations guide how they work in practice. When a dispute arises, the plaintiff brings the case, and the defendant answers before a court that has proper jurisdiction. Both sides are represented by counsel, who present evidence to the judge. Under civil law, judges rely on written codes. In common law, they follow precedent and case law to ensure consistency. The final judgment resolves the dispute, enforcing obligations or assigning liability to those responsible. Together, these concepts form the living language of justice, where reason, fairness, and accountability unite to uphold the rule of law across all systems. You've now learned 20 of the most essential terms in the language of law: concepts that connect every legal system, from civil to common law. But true understanding comes from practice. The more you use these words in real contexts, during client interviews, negotiations, and document drafting, the more naturally they'll become part of your professional vocabulary. Inside our legal English community, you can take this knowledge further. We hold live interactive sessions where lawyers and students work together through real world cases and improve. You'll also gain access to full lesson modules, guided exercises, and practical tools to build confidence in legal communication. If you're ready to move from memorizing terms to applying them fluently, join us today and start mastering legal English in real professional settings.